what's going to happen throughout the day, and Bree will be with you as we move through these rooms. You will get, at certain times, we will give you some notice though, a wee screen that comes up, a box on your screen that says that you're going to be shifted into a breakout room. Please press OK. If you leave that breakout room, we can't put you back in. So if you could just press OK once, you'll go on into the room, and then we will. finish up. I think.
Kia ora tātou, Tamariki Kings, mena kai kuna koe, kai a koe te karakia. I muri tērā, ko hoki mai te mihi whakatuwhera ki au, ka hoki atu ai ki a koe hai whakahoti. Kia ora.
Kia ora e pōu muna whakamārama, te tīmatahi ake e karakia mātātai. E kai te atua kahara wa tēnei rā mātau, ka kōru piko atu ki moi tō waro te hawa tēnei ake. E hoki te kāru e pā te atua kahara, te kaupapa e hui nei mātau tēnei rā. Te runga kāriru ki te pōi whakatau whakaaru ai, whakatau kōreru ai, ki mai tēnei kaupapa e pā te atua kahara. Pero tō rā rātau i o ringa i roto i ai manaki tanga i tēnei wā. O mātau e nei ngā mōre hu e pā te atua kaharawa, tai noa ki ngā whānau ki ngā whānau whakarere ngā iho, a rātau mā kāriru ki te pōi roto i tēnei kaupapa. Ka tuku atu nā whakamuimi te kia koe moa au waratakina, moa au manaki tanga i a mātau, tai mai ai mātau ki tēnei rā, i whai whakaroa noa i mātau e pā te atua kaharawa, i te kaupapa nāna mātau, i whakahui tēnei atu. Nō reira kia tau mai au manākitanga, ki runga ki tēnā. O mātau hapu, o mātau iwi, o mātau whānau e marara nei runga i te mata o te whenua. Ki te arahi a mātau i roto i ngā kaupapa whakatakotoranga i tēnei rā. O ia nei rā, ka tuku atu nā whakamoini tui. Nā mātau ino i kia koe runga i te ngō tāu tama. O tō mātau kai whakaora, oi hukraiti. Tōri e ki tōi ngā tapu. Amen.
Amen. Te rangatira tāmati, tēnā koe e hono nei i te ihu o te whenua ki te ihu o te rangi. E whakatutuki nei i ngā tikanga whakarere iho a ngā kai arahi a tātou ōmua. Anō reira, tēnei ka mihi ki a koe. Kia koutou ki a tātou kua hui mai nei tēnei rā. Aha koa he tau hou ki tēnei momo hui ngā mārunga ipurangi. Koe nei rā te huarahi e wāte ana ki a tātou i raru i ngā pēhitanga a te mate uruta korona. E tai ahia nei te hau. Mā e nei huarahi hangarau e ora i tō tātou whakapapa. Nō reira, ka mihi rā, kia koutou i o tātou mate. Ko te kauri nui tēnei o ngā puhi kua turakina nei e aitua. Nō reira e kara, takoto i te moenga tēwhita, te moenga tērea, te moenga te whakaarahia, te urunga tētaka. Haere atu rā koe i te tai awatea, mā muri e whai atu i te tai ahiahi, ko koutou kia koutou. Kia huri iho kia tātou, ki te hunga ora tēnā rā koutou. Ngā roia, ārahi i ngā tāngata, nā rātou ngā kereme, mō tēnei kaupapa ko te pūtake, ko a tātou tamariki. E he kama, ko a tātou tamariki rā, tō tātou a pōpō. Koe ni tō tātou a namata. Nō reira, e tika ana kia noho tātou ki te kōrero, kia noho tātou ki te matapaki, ki te huri I ngā kaupapa e pāna ki te oranga o a tātou tamariki, o a tātou mokopuna, o a tātou kōhungahunga, e pēhia nei e ngā mate urua atu ki roto I ngā whare tiaki a tātou. Tainua hoki ki ngā mātua e tohutahua no ki a tātou I roto I rā kōrero. Nō reira, tēnā koutou hei ngā roia, me ngā kai kere me I haere mai ki te tautoko I o koutou roia. Tainua hoki ki a koe te krauna, ko koe nei te aronga o ngā mamae, o ngā riri o te iwi Māori. Tainua ki a tātou ki te rōpū whakamana I te titi o Waitangi, te kai whakawā, ahorangi Rāwinia, Kim, tainua ki a koe awhia, tātou katoa, me ngā kaimahi o te rōpū whakamana I te titi, tēnā koutou, kia ora tātou, tēnā tātou katoa.
Hei te rangatira, hei te karangarua, hei te hoa, e pō. Tēnei koe te whakare wāke nei I te tāhu o te kōrero o te kaupapa nāna tātou whakahui tēnei atu. Ka mihi ki te ahuatanga. Mihi ki te ahuatanga e maranga ke te rāpiti o ia tērā ko te pua o te tūno. E nei tōna haere e tore mi atu ia ki te uru, ki te pō, ki te tāheke roa, ki te ngarotanga atu o ngai tātou kāriho ki te pō. Nō reira he mihi ake ki te ahua o tō whakahua I tēnā rangatira o te ao Māori kāriro ki te pō. Atahi anō kāro o tēnā hu. Haunga koa ko te ahua o te mate urutā e pēhi nei I te ao. O ia tēnei e noho nei tātou. I noho ai tātou I ringa I te ipurangi. Kōrero ai kia tātou. Nō reira ka mihi ki o tātou mata. Ki te kaiwhakawa, ki te rangatira, o te tira, tēnei rā ka mihi ki a koe. Ka mihi ki a koe kai te rangatira, kai te kaiwhakawa e whakahaere nei I tā tātou kaupapa I tēnei rā. Ka nui te me. Kai te karangarua, Rāwinia, te ahorangi o te whare wānanga o Wikitoria, tēnei rā ka mihi nui ki a koe. Ki te marangatanga ki o tērā, ki te toka e kore nei e neke hikurangi maunga, kai te whaia, tēnei rā ka mihi ki a koe. O tērā ka mihi ki a koutou katoa, I runga I te pae e whakahaere nei I tā tātou kaupapa. Nō reira kia huri tonu ake ki te ahua o te kaupapa, nāna tātou I whakahui tēnei rā. He aroha ke rā ki te hunga, ka riro I roto I nā whakaaro I whakatakotori ai, I o nara. Kua toru te kaumārima tau, te takotora ngātu, te takototanga mai rānei o te kaupapa o pua o te tatu, pua o te atatu. I ngaro atu ai te hunga, nā rātau I kōkiri, I e rārā. I ngaro atu ai hoki, te hunga, I whakatakoto kore, I te rawa. Kua toru te kaumārima tau tērā. He ahuatanga o ia pea, te tū manako nui I putai ona kōrero I tērā wā hai whakatakoto I te papa hai whainga mā tātou kāre I tatu I te krau. O tātou e nei, e noho nei I tēnei rā. Heoi he whakaroa ke ki te ahuatanga o nā hui nui I whakahaere hia I tērā wā. E toru te kau mā whāpei nei ngā hui huinga huri te motu. I whai wāhi ai, o tātou whānau, o tātou hapu, o tātou iwi, ki te whakatakoto whakā. Kua tae anō tātou ki te rāua, he tonu ake rā, e kene, me hoki pērā anō o tātou whakāro. Kia whai wāhi ai, o tātou whānau, ki te kōrero, ki te kaupapa, e hui nei tātou i tēnei rā. Kua takoto i te kaunihera Māori o na whakaaro, a puka puka mō ngā pātai e toru i pātai hiai e te kai whakawā o tēnei hui ngā tāta. Kua takoto ngā kōrero. Kei reira tonu te kōrero e ki ana homai a mātou tamariki mā mātou hei whakahaere. Ka tika hoki e kōrero. I kōrero hiai e koe o te whakapapa, o te ira tangata. Hoia te tīmatanga mai e noho nei tāta. Ka noho a tātou tamariki i runga i tērā i te manaki i te ira tangata, i te manaki i te whakapapa. Kāri ko atu, kāri ko mai, whakahokia mai a mātou tamariki, mā mātou anō, mā te Māori, hei whakahaere. Kei te mōhio mō ngā uauatanga o tērā pātai. Engari kua taipea ki te wā, i whakamātau hiai e o tātou tīpuna i te tau tahi mano warurau whātekau kia noho tātou i te taha o te grauna. Kaua ki roto o te grauna, oi nei ka arohake ki te āhuatanga o tātou tamariki. He whakamātau nui ae, i te whakahaere a tātou. Enari kua tatapea e rāwa. Oi anō kai te rangatira kai te hoa, e pō, oi anei nā whakaaro hai tīmatāke i roto o a tātou kōrero. Nō reira, huri te pae, whakahaere tā tātou kaupapa, tēnā koutou, tēnā koutou. Huri tō tātou, huri te motu, e whakarongo mai nei, e mātakitaki mai nei, tēnā koutou, tēnā koutou, tēnā tātou katoa.
Hoki atu ki a koe, Judge.
Mōrena koutou, tuatahi, tēnei te mihi atu ki a koe, Mr. Cairns, nau i whakakākahu tā tātou hui ki te korowai o te atua. Nō reira, tēnā koe. I tautoko ana ahau nā mihi kua mihia. Tēnā koe pau. Ka mihi hoki ki a koutou kua huihui mai nei ki tēnei ao hau. Me ki nau mai te taumata tuarua. Mōrena, first, welcome, and if I could just introduce the panel. Of course, Ahurangi Pau Te Mara, Ahurangi Rawiniya Higgins, and Ms. Kim Narimu. I'm also pleased to welcome Council assisting the panel, Ofa Cassidy. At this point, I'll just ask Ofa to make herself known to the parties. So, kia koe, Ofa.
Tēnā koe te kai whakawā, tēnā koutou hoki aku rangatira e noho nei ki o koutou kainga i tēnei wā o te mate krauna. Ka tuku mihi atu ki a koe te kai karakia nau anō i whakatuwhiratia i tō tātou nei hui i tēnei wā. Ka rere taku mihi hoki me ki te taumata, koutou e aku rangatira, nā mihi nui ki a koutou hoki. Ko Auwha Cassidy tōku ingoa, he uri a hau no Ngāti Parau me Ngāti Whātua. He roi a hau I roto I te kōti a whānau me te kōti rangatahi. Tata ki te rua te kautaupua pahure I mahitia e au I roto I tēnei tūmomo mahi. Anā reira tēnā koutou katoa.
Kia ora. I'm going to ask Council for appearances by way of a list that I have. Ms Sykes, I understand there is a matter you wish to raise, which I'll come to after appearances, and just a few logistical matters. First, Tamata Law.
Mark, sir. David Stone speaking. I'm here with Miss Catherine Laonga. She's at her home. We appear today for Y2823 and Miss Jean Tahuia. Marilyn Stevens for Y2615. And Your Honour, we submitted a claim 2641 for Rex Timu. And we're just waiting for whether or not that claim can get into this inquiry. But good morning to everyone. Kia ora.
Kia ora, Mr Stone. Ms Luega. Ms Sykes.
Morena tātou, I hui mai nei, I rongi te kaupapa hohunu, I raro hoki I te maru e kia nei mo te mate krauna. E whakaro ana he tino irony tērā I rongi tēnei whakahaere. Kei te tūau hoki ki te tautohu ngā mihi ko mihia, I te tohunga I whakatūpera ko tātou nei hui. Kia koutou hoki I whakatau I ngā whakaro a tāhua mo te kaupapa nei. Ko hau hei roia hei māngai tautoko mō ngā kreme e rua. Ko te tuatahi, he kreme I muri a tātou e whai atu mai ngā nehi Māori o te ao, ngā midwives katoa. Me wera atu o ngā tāngata I mau here ai, I rungi te pakaro kino o te krauna, me noho rātou hei wards of the states. Me wera atu o ngā tuahuatanga e pāna ki wetahi o ngā tohunga e whai whakaro I ngā wharewānanga mō tēnei. Ko Dr. Rawiri Waretene Karena, ko Dr. Jane Allison Green, and ko Kiri Nuku nā kaiwhakahaere mō tērā kreme, Y2891. He kreme anō I mui a tātou I puta mai tētahi uri o Te Arawa, Ngāti Parau, Ngāti Hine, a Donna Awetire. He tino nui ngā tohunga hoki o tēnei kaupapa hei āwhina I aia. Ko Paula Moyle tērā, ko Susan Devoy tērā, me wera hoki o ngā tāngata I taka I te hara nā te whakahaere o te kōti whānau. I reira katoa rātou, e whakarongo ana I o rātou nei kāinga, I runga I tētahi o ngā whakaro puta I te tribunal, and kei te tautoko I te kaiwhakawā, kei te hiahia au, me kōrero me pēhia te whakahaere o tēnei rā, kei te kiti atau, e nui ngā kai kreme hoki, I rungi tēnei o ngā Zoom hui, e whakaro ririke tērā pia, ki te whakatau o te tribunal, I mua I te timatanga o tēnei whakahaere. Kia ora tātou. I don't propose to change dates here, but it's lovely to see everybody after 7 weeks. Kia ora.
Kia ora. Thank you, Ms Sykes. Mr Benyon.
Tēnā koutou katoa, tēnā koutou te tepu. Mr Benyon here with Genevieve Davidson, and we're representing two claims. Y1911, that's Aaron Smale, Tony Jarvis, who've been active also in the Commission on State Care, and then a claim 2408, that's Tessa Aporo, which is a whānau claim about intergenerational uplift. And for that second claim, Mr Aporo's claim, we're awaiting a decision on aggregation into this inquiry.
Tēnā koe, Mr Benyon. Kia ora, Ms Davidson. Tukau Law. Ms Downs or Ms Rolleston?
Tēnā koe I te kaiwhakawa. Aroha mai, Ms Rolleston was going to give this, but she may be having issues with her technology. We appear this morning on behalf of Y1464 Te Kapotai, Y682 Te Runanga o Ngāti Hine, and Y2616, a claim yet to be registered, sir, which is on behalf of Ngaitirangi. E mihi ana kia koutou.
Tēnā koe. Kia ora, Ms Downs. Tamariki Legal?
Tēnā koe, sir. Council's name is Roughton. I'm appearing today on behalf of 3 claims, sir, all of which are waiting on a decision as to whether they'll be participating in this inquiry. They are Ms Tienga Harris and Lee Harris and the Harris whānau. That's Y1531. Ms Tasi Huadama, the late Zipporah Huadama and the Huadama whānau. That's Y2890. And Miss Mona Verco Cliff and the Cliff whānau, that's Y2863. Kia ora.
Kia ora. Thank you, Ms Roughton.
Thank you.
Roy Mata Smail?
E te rope whakamana I te tiriti tēnā koutou. I appear for the Y2941 claim by Lady Tūreiti Moxon on behalf of the National Urban Māori Authority and its members and the whānau they care for. Ms Moxon is watching the live stream on YouTube. We've also filed an urgent application last year and sought to participate in this inquiry. Tēnā koutou.
Tēnā koe, Ms Smail. Dixon and Co.
Tēnā koe te kaihakawa o te kia koutou katoa. Ko Leisha Castle tōku ingoa, appearing on behalf of Ms Aroha Rere Te Crofts for the Māori Women's Welfare League and also Ms Dallas Pickering, who both await registration of their claims and seek to participate in the inquiry.
Tēnā koe, Ms Castle. Mr Gilling or Dr Gilling?
Tēnā koe te kaiwhakawā, me te rōpū katoa. May it please Your Honour, Council's name is Gilling and I appear with my learned junior Ms Soriano. And we represent Y2916, claimed by Piripi Gray, who has also been actively participating in the Royal Commission.
Right.
Tēnā koe.
Tēnā koe, Mr Gilling. And Ms Soriano. Ranfurly Chambers.
E tiriti o Waitangi tēnā koutou. Council's name is Te Atairi here Thompson and I appear with Mr Tupara. The claim we represent is 2217 on behalf of Queer Violet Nathan. It's currently sitting with the registry team and we're also waiting on participation of the claim in this inquiry, a decision. Mihi.
Tēnā koe, Ms Thompson. Kia ora, Mr Tupara. Woodward Law.
Donna Hall here, and with me is Mr Lyndon Rogers and a number of clusters comprising members of the district Māori councils of the New Zealand Māori Council. It may help, sir, if I just quickly identify the clusters so you have an idea of the grouping. You'll be pleased to know that everyone understands there's not a lot of time, but if you know where they are and who they are, then you'll be able to take a note of that. If I can just begin, sitting here at our office with us is Tamati Kens. He is a co-chair of the Pukenga group, which advises the New Zealand Māori Council, and in Te Teko with a cluster of representatives from the council with considerable expertise in this topic is Ms Winnie Geddes. So there are 2 co-chairs, sir, for the New Zealand Māori Council Pukenga, One here with my office and the other, Miss Geddes, is in Te Teko, and with her is Mr. Tane Cook and Miss Taina Boasa Dean, who are both members of the council. Sitting in South Auckland, we have Miss Anne Kendall, the queer of the Papakura Marae there, and with her is Ms. Raywin Bana and Mr. George Ngatai, and the chair of the South Auckland District Māori Council, Roimata Minhinik. The third cluster, based at Waipapa Marae, is Derek King Huata, who is the chair of the Takitimu District Māori Council, and accompanying him is Mr. Ngahiwi Tomoana, who is also here wearing his hat as the chair of the Ngāti Kahungunu Runanga, and Ms. Ngātai Huata. They are there, and there are possibly others too with them, but if you just could call them for purposes of convenience the Waipapa cluster. The fourth cluster, sir, is based out of Rotorua. It has Dr. Ken Kennedy, Ms. Paire Hunu and Miss Rangi Wade there. The fifth cluster at Te Tai Rāwhiti is the chair of Te Tai Rāwhiti District Māori Council is Mr. Owen Lloyd, and Miss Maurice Lant is also there at Te Tai Rāwhiti. At Wairau, we bring an apology from the last of the Te Tai Rāwhiti clusters. They're not able to be here. Then we have 1, 2, 3, 4, 5. We have the Auckland Central cluster. This is Ms. Raywin Harrison, who is the deputy chair of the Auckland District Māori Council, and with her is our queer Ms. Alamaine Emery. There may be others with them. And then we have a series of chairs who are on a listening capacity for their district Māori councils. Just going through them quickly. Ms. Ngaio Te Ua for Te Waipounamu, Mr. Wiramu Puriri for Te Tai Tokerau, Mr. the Venerable Archdeacon Harvey Ruru for Te Tauihu at the top of the South Island. In Bennydale, we have Ms. Jean Nankiville for the Maniapoto District Māori Council. And I think that's everyone, sir.
Right. Kia ora, Ms. Hall. Tēnā tātou katoa. Thank you. Lyle and Thornton.
Yes, kia ora, sir. Lyle here. I am here on behalf of Ms. Vicky Tiora Maureen Mitchell. She's seeking to be an interested party to this inquiry. Her claim is Y1247, and I understand that's before you for a decision.
Thank you, Mr. Lyle. Phoenix Law.
Tēnā koe, sir. Ms. Mason appears for a number of different claimants. The first one is Y2846, and those claimants are Mr. Cletus Manu Paul on behalf of the Matatua District Māori Council. And so I'll just let you know in advance that there is some contention between some of these district Māori councils, not a matter for the tribunal, but just in case you're hearing double, the issues before the High Court. And Mr. Diaz Ratima, the chair of the Takitimu District Māori Council, Ms. Diane Black, the chair of the Tamaki ki te Tonga District Māori Council, Raymond Hall, the chair of the Tamaki Makaurau District Māori Council, along with Ms. Tirewhai Harawira, and Mr. Rihari Dargaville, who is the chair of the Tai Tokerau District Māori Council. And they are the Y2846 claimants. And there are a number of claimants who are in varying processes or various stages of registration. And that's Ms. Collier, who's Ngāpui, Mr. David Potter, who's Ngāti Rangitihi, Ms. Te Amohia McQueen and Albert McQueen, who are from Waikato, Maniapoto, Mr. Henare O'Keefe, who is from Hastings, Ms. Carper, Ms. Jane Ruka on behalf of the Grandmothers Council of the Waitaha Nation, and most importantly, the mother of the Pepe who was to be uplifted in what is referred to as the Hastings case, and her whānau, and a number of other mothers who have had their children uplifted. So appearing with me today is Mr. Bruce Asher from our offices. Thank you, sir.
Thank you, Ms. Mason. Kia ora, Mr. Asher. NL Lawyers.
Tēnā koe, Your Honour. Council's name is Mrs. Nāpō Lipscomb, and I appear with Mr. Kanawa, who said it to Council's right. We filed a memorandum dated the 20th of March in anticipation of the potential conference, and I've listed in there the claimants that we represent. The first claimant is Y2895, Ms. Nicola Dalipaki. The second claimant is Y2937, Noeline Hughes. Y2939, Vanessa Taupaki. Y2948, Ms. Cara Lindsay. And Y2938, Denise Mesata on behalf of Te Whāriki Mana Waihine o Hauraki, the Hauraki Māori Women's Refuge Centre.
Thank you. Tēnā koe, Ms. Nāpō Lipscomb. Kia ora, Mr. Kanawa Gwyn. All right. I'd just like to make a few preliminary comments. First, thank you to all parties in Council for participation today and for the assistance you've been able to give the Tribunal in what are difficult circumstances. Please bear with us today as we work out how to conduct a conference remotely. We anticipate that it'll be difficult to get through the entirety of the agenda we set, and we have for that reason allowed for filing of supplementary submissions in writing next week. Oh, sorry, Ms. Hardy, I omitted to call for appearance from the Crown. Kia manawanui mai, Ms. Hardy.
E te kai whakawā tēnā koe e ngā mema o te roku whakamana tēnā koutou, Ms. Hardy, Mr. Tyson and Ms. Mackay for the Crown.
Thank you. And I understand you have a number of officials in attendance also?
They're watching the live stream, Your Honour.
All right. Thank you, Ms. Hardy, and my apologies again. All right, the other preliminary matter I wanted to note was the delays that have been occasioned to our registry function, largely because we've been unable to have staff in attendance at the offices until very recently. I think as I indicated in recent directions, the range of parties seeking to be heard before us reinforces just how important this taki is. We are behind in the normal process of registration, and the indication I wanted to give today was that so far as is possible within the boundaries of the issue that has been referred to this panel, we propose to take an inclusive approach to participation and registration of claims. The real challenge for us collectively is how to design the inquiry around scope and timeframes that still fit within the concept of an urgent inquiry. And that's one of the primary matters we will be discussing today. So we anticipate advancing the registration of outstanding claims and completing that task as soon as possible. And further directions will issue updating parties after we've received any further submissions at the end of next week. Now, in the last couple of days, the Tribunal received a request from Ms. Hall on behalf of various Māori Council districts for participation today. And Ms. Mason, I note and am aware of the ongoing litigation in the High Court. I issued brief directions yesterday by email, and I think through miscommunication on my part, they weren't circulated to all parties. So I'll just very briefly read the direction I gave in response to Ms. Hall's request. This also, I think, in part addresses the issue, Ms. Sykes, that you had raised with the registrar just before we started. So I'll just read for the record the direction I issued yesterday. I asked staff to record that I accept that the New Zealand Māori Council has an important function, and that the representatives whom Council have sought participation for have significant and relevant experience, and I granted leave for participation as requested, subject to logistical requirements. Council are to please note and inform their clients that the Judicial Conference has a full agenda with a large number of parties to be heard. The panel would be assisted by short and focused submissions from the proposed participants. The presiding officer is also conscious that a number of district Māori Council representatives are participating in this inquiry under the representation of Janet Mason. The primary purpose of this Judicial Conference is to advance inquiry planning, particularly regarding the question of scope and contextual hearing preparation. And I have therefore asked that the panel would best be assisted by a common approach to these matters as between those represented by Woodward law and Phoenix law. So how we propose to proceed in terms of the agenda is to call for submissions starting with the question of inquiry scope and starting with the joint memorandum from or filed by Tamata Law, and after hearing from the various claimant counsel, we would then seek a response from Crown Counsel. Now, Ms. Mason or Ms. Sykes, is there anything arising at the moment?
So I'm not here or in any capacity to represent anyone from the Māori Council, so I don't think your directions of yesterday cover my concern. In addition to what you directed, we received an email from the registrar late yesterday afternoon directing us to forward it to our claimants and witnesses so that they could have a link, not by Zoom, but by video conferencing link, which of course means they cannot participate viva voce. And I'm concerned if there are going to be matters, and I'm reliant on my witnesses, sir. I know there are 7 midwives seated somewhere in Hastings, sir, that are relevant in planning and scope, and they certainly were going to be participating in any contextual hearing that had been contemplated in your earlier directions. I have a witness in Canada, I have a witness in Australia, and I have witnesses in Waikato that are watching. And I just don't want them to be disadvantaged if we suddenly have, and I'm not saying it's inappropriate, but we suddenly have viva voce matters being raised, and they aren't, of course, able to be instructing me today. And I just raise it, and I also raise it in terms of time of this conference, because we've tried to develop a cooperative approach to limit participation so we can get on with planning, and I just raise that.
All right, thank you, Ms. Sykes. Ms. Mason?
So I just reiterate really what my friend Ms. Sykes has said. It's just in the interest of time and fairness, because we all thought that this was a JC for council only to go through scope, and perhaps others of my clients would have wanted to have been present here, but they haven't. But
right.
Of course, we'll try to work together with everyone. So,
thank you, Ms. Mason. Can I just say, it goes back to the point I made a short time ago, that the information so far provided to this tribunal by the range of parties seeking to be heard has made it clear to us that there is a significant need for us to take as expansive approach as we can within the bounds of an urgent inquiry, to hear from a very wide range of persons who have both professional and personal experience to relate. The first point that arises from that, and just by way of a preliminary observation that might assist Council when we come to our scope question and to the question of the approach to context hearings, what we have by way of preliminary view is the realization that 2 days for the context hearings is likely to be insufficient. We think that there is some merit in the submissions made by a number of council, that it might be better to regard what we have described as context hearings as more in the nature of substantive hearings in their own right, albeit with a focus on what we have described as the underlying systemic issues. The idea then might be that we start with hearings focused on those systemic issues, and that we hear from those organisations and individuals who are able to speak to the systemic matters, and then move to a second phase of hearings focused more on personal and case study type evidence. So that raises a question about how much time we will need for the contextual hearings and what are the necessary procedural steps to get us in a position where we can start those hearings. And at this point, I just also indicate that it is our proposal that in relation to the question of case studies and the question of remaining issues to be considered in relation to what is known as the Hastings case, what we propose is that Crown Counsel and Claimant Counsel involved liaise in the next phase with Ophir Cassidy, and that there be dialogue at council level with Ms. Cassidy reporting to the tribunal on those matters that are going to require further direction from the tribunal. So with those preliminary remarks, I'd like to start with the first matter on the agenda, inquiry scope, and was going to call first on Tamata Law or the representatives to speak to the joint memorandum. Now, in terms of our timetable today, we've already arrived at the time that was scheduled for a first break. I think we'll keep going until we've heard from the submissions from or on behalf of council supporting the joint memorandum, and then we'll break at that point. Ka pai? So, Mr. Stone, will you be speaking to the joint memorandum?
No, I think the different contributors to the joint memo might be taking a tag team approach, sir, if that's all right.
All right.
Sir, the tribunal has our memorandum. I'm very aware of the time restraints that we have today. It's not my intention to read it verbatim, that Your Honour and members of the tribunal can read it when they wish. So I would like to start by saying what this, well, in my submission, what the scope of this inquiry isn't. And in my submission, what this inquiry isn't an opportunity for all those who have been parties to family court proceedings and who have been dissatisfied and unhappy with the outcome of their respective hearings. This isn't an opportunity for them to have another go. Just because someone has been dissatisfied with a particular outcome of a court sitting doesn't necessarily mean that they're then qualified to bring a claim to this tribunal. I say that because I'm not sure if Your Honour saw the uplift video with the Hastings case, but I was there. I was literally in that room, and I was there when all that happened. And I'm the only lawyer that can say that. And as a direct result of that, my phone and email has been simply flooded. And for the most part, I've turned them all away, in the sense that I said to them what I've just said to Your Honour, that just because you've been in the family court process does not necessarily qualify you for submitting a claim. That said, the common issues that did arise that I thought were or could be the subject matter of pleadings have been pleaded to in the originating Y2823 application, because Jean Tahuya, who that was submitted on behalf of, she as well was in the room on the day that the child was during the attempted uplift. So I just wanted to start with that, sir, by saying what my submission, this inquiry shouldn't be. It's not an opportunity for everyone to have another go. So you have our submissions there. Are there any questions specifically that Your Honour may want clarification on?
The issue of scope, Mr. Stone, and I take your point around the limitations on what's properly within scope. but taking the most recent directions from the tribunal, which proposed the forming some kind of agreed statement of facts, from which a focus could then shift to the primary question of why there is an established and persistent trend of disproportionality in the number of Tamariki Māori taken into state care. And then from that issue, a focus on what the recent legislative changes do or do not allow or provide for, and what further changes might be required to promote treaty consistent outcomes. So on those matters, Mr. Stone, do you have any further submissions to make?
The other authors to the joint memo might have submissions, sir, but I'm quite happy to have my submissions taken as read at this point, Your Honour.
All right, thank you. Do any other council who are registered in support of the joint memorandum wish to address that issue?
Mr. Benyon, sir.
Kia ora, Mr. Benyon.
Yes, sir, just several matters. The first is to say that in terms of context, just two or three things that come up. One is that the Crown in its latest memo has referred to historical injustices, which seems to take us a long way back. I don't know that we want to go that far. Maybe we do, but we've got another date in terms of context, which is 1989 and Wau Te Ata Tū, and the development since then, and you've said clearly that that's within scope in what we're looking at. But we also note in the latest memo the issue of intergenerational uplift and this startling statistic of 48% of pregnant women whose children have been taken, Māori women whose children have been taken into state care, had been in state care themselves. So if we think about those three matters, we say that, and I don't know if this is entirely, we certainly cover that in the memo, but it starts to look like we are looking at a full inquiry from 89 forwards, but we need some context around pre-89 matters, and there is a question how far back we go with that. And just the other thing to also note quickly is that in terms of scope, we do need to be clear about the idea of uplifts that are occurring, and there's some question about whether those uplifts are declining in number. Be clear about that, as opposed to the Māori population in state care, and you want to pick that up with the Len Cook statistics, that we understand we're looking at both matters, both uplifts and the numbers there, but also the numbers remaining in state care, because Len Cook points to that disproportionality in particular being relevant and actually being a real source of concern, because that is growing quite quickly. So all of that suggests, in our view, that we agree with what you say about the contextual hearing having to take a little bit more than two days, and those. So it also suggests that the Crown proposal of a sort of a beginning chronology that might go towards agreed facts is going to be an important document. And it also suggests some care needs to be taken in terms of not going so far back that the contextual inquiry becomes too large, but we do have to at least start to look at things like intergenerational state care, because, say, 48% of women who've had children taken, Māori women who've had children taken into care have themselves been in state care. Just not something we can overlook. The tribunal itself has said we're looking at systemic issues.
All right.
Those are my comments there.
Thank you, Mr. Benyon. And just for those who may need the reference, the document, the joint submission we're referring to as document 3.1.90. And Mr. Benyon, just a quick question in response to your submissions. And I just want to test with you a proposition really that goes to how an agreed statement of facts or chronology could be considered. It seems to the panel as one way to approach the issue that has been referred to us is to start or to look to the Po'o Te Atatu report and to the changes that subsequently followed, and to ask why, notwithstanding what generally seems to be accepted as an accurate articulation of the problem and comprehensive recommendations for change in Po'o Te Atatu. So notwithstanding that, how do we now arrive at a situation where the matters that you have just highlighted have become embedded or further embedded in a systemic way? Is that a fair premise from which to possibly build a context or an agreed statement of facts that would enable us to focus in a more narrow frame on the more recent legislative changes?
Thank you, sir. I know there are so many people on this call who have a good answer to that question, and I can only say that my understanding is that that report was a significant moment. So my understanding is that from what I read and hear from claimants that it's a place to look backwards and build forwards. But I know there are others on this call who will have a lot better answer than me on that question.
Thank you. Any other council in support of the joint memorandum wish to speak at this point?
Ms. Sykes here. I'd like to try and weave some comments both with respect to that memorandum, the directions from the Chief Judge when he granted urgency, and some propositions that have been made by the Crown about scope and context. I think the first issue is, should context go before scope? I have a real problem that if we have expert witnesses who are giving arm's length testimony of what are very personal stories that have caused significant harm intergenerationally, we will have a different approach than what my claimants are expecting. I'll just put it in those terms. And if you go back to the original directions that granted urgency, I think, and which is at paragraph 8 of our memorandum, methods of uplifting children, cases of abuse in care, standards of care, historical grievances need to inform scope, sir. And if you haven't had context, then your scope may be limited by the fact of those expert witnesses that are relying upon not knowing enough about the personal experiences. I'm in the fortunate position that I act for two sets of claimants, and I'll start with Y2494, the claim by Donna Awatiri-Huata. Its genesis was when she was a member of the panel on accord that looked at systematic abuse in Weymouth prior to Pu'au Te Atatu, and the strategies of uplift that were then being employed, and the racist conduct of both police and social welfare officers at that time, and Māori affairs welfare officers. I think they keep getting forgotten about that caused a disproportionate taking of children from Māori whānau at that point. That's before Puao Piatatu. Those matters are listed in the numbers of pertinent matters that we set out at paragraph 9. But of course, that was what we did, really responding in the short time frames, because we didn't get your direction until May the 7th. Then we got the Crown's one. So I am grateful that we're going to have a little bit more time. Some of my expert witnesses are looking whether that list should be expanded. But the chronology is in there, but you'll have to go deeper, Sir, within many of those reports to get a full picture of the practices of uplift and the systemic abuse and racism that set a path of outrage in the early to mid-1980s. That then saw Te Puao Te Atatu, that then saw a committee led by great Māori women leaders, Lena Manuel, Mirasazi, the late Eva Rickard, who were all part of a social welfare committee that's then set the basis for the genesis of the Children, Young Persons and Their Families Act, and why whānau was so important as a pivotal fact in the reconnection of children with their whānau, which I think is a key issue before us here. So in terms of your proposition that's put, yes, a chronology can be developed. My concern is if you have scope without context, then you may miss fundamental issues. So then I look to what is the evidence on the record now to provide context. And there is significant evidence on the record now, but I do think there needs to be a proper opportunity for social workers, for instance. They were some of the main witnesses in the Accord testimony. Oliver Sutherland, Professor David Williams, Jane Kelsey, Professor Jane Kelsey, Donna Awatere Huata, who was the first Māori psychologist. They were pivotal in setting the scope of that inquiry. And
Sorry, which
I just
inquiry
think
is
we
that?
can't help but forget that, Sue.
Sorry, Ms. Sykes, to interrupt. Which inquiry were you just referring to?
The Accord inquiry. The Accord inquiry? It was an inquiry done in Auckland into the practices of racism for children and young persons that were being gathered up by the police at that time. The second issue that I've also raised, Sue, is that I'm acting as counsel for claimants like Mr. Gilling, who are presently giving testimony before the Royal Commission on State Abuse. And as I understand or appreciate the terms of reference of that Commission of Inquiry, they will be grateful for any information or findings from this inquiry that can facilitate their understanding of institutional racism, which I think is also a key significant issue here. So while there are different terms of references, I think there's going to be some crossover. And my sense from that inquiry is they're waiting for your decision. So I just want to be, I'm very conscious, I don't want witnesses repeating things over and over again before different inquiries without recognising the personal harm to them that the repetition of evidence will give to them. And I've already seen it with many of the, I represent a number of men who've been in jail for over 20 years in that inquiry, who are all state wards. And we've only got some representative examples of them, their testimony before this inquiry. But, you need to remember that I think there's over 200 that have given testimony either privately or in confidential terms or publicly of the abuse they suffered as state wards since the 1960s, and some of them since the 1980s. And that I don't want, and I just raised that as to, I think Mr. Stone expressed it, that we don't want to relitigate questions of the family court. Well, I don't want to re-traumatise any witness in giving their experience to establish state abuse that they have suffered and institutional racism that continues. So that moves me to your direction, Sir, recent. You've asked whether there's appropriate concessions, and I'm grateful to my friend's concessions. Ms. Hardy's memorandum is sensitive, and I think we're starting to get to some significant points of convergence around the kind of discriminatory practices and uplift practices that have caused harm. But I don't think it needs to, I think it needs to be more specific than the generic acceptance that her current memoranda sets the framework for a process of reconciliation and resolution that this tribunal, I think, can provide. So I just make that also when we set scope. So when we do the chronology with Crown, whoever does it, whether it's counsel assisting the tribunal or appointed senior counsel here, I think there should also be a recognition that that process should be getting some specific concessions from the Crown early, not generic concessions.
Right.
That's one of the things I'm anxious to include in your contextual weaving of issues for the scope.
Thank you.
If you go to paragraph 5, we've tried to find some language to give expression to our concerns. And I don't wish to add more than that. I think Mr. Benyon has covered that really well. But what I do remind this tribunal is that we've got reports coming from the Office of the Children's Commissioner. We're still awaiting the 3-month, the 0 to 3 months inquiry by the Ombudsman of uplifts. And I think those reports are also going to be extremely important in setting the scope of this inquiry and concessions. I just raised that. They were expressly mentioned in our first memorandum, but haven't been noted in this one. My last comments really relate to timing and the contextual hearings and where they take place. The Hastings example drew focus to what is happening right around the country. And that's what I think there needs to be some precautionary approach, that we don't just all latch to this Hastings example. That's all I say. I'm aware, and my friend Ms. Limskin may be able to give better evidence on this, I'm aware of quite considerable concern of uplifts that have occurred in the COVID-19 of equal stress and prejudice as what has happened in Hastings. The practices haven't stopped yet. So that needs to also be kept in mind in timing of our process. If we really want to effect immediate change for these practices, then we need to get some relevant information about context and the prejudice that is occurring in an ongoing way to inform scope.
Right.
But I just emphasise that point. I mean, that's why, and selecting the kind of contextual witnesses, or I just think there needs to be a mix of lay people or tohunga, or people who've suffered harm, and not just academics. And that's all I'd like to say, sir.
Thank you, Ms. Sykes. Just one question in relation to paragraph 9 and that list of policies and practices. If we accept the submission that all of those matters are relevant in terms of underlying context, what level of information or analysis would we require in your submission of this, or all of the matters listed in this chronology? Is that something that a suitably qualified researcher may be able to prepare some form of overview report? Is that the approach you had in mind?
Yes, sir. I want to say that in the Royal Commission on State Abuse, that kind of evidence has already been collated of some of these contexts, not so much from a Māori lens. Can I say that? That's why I think a researcher commissioned with a kaupapa Māori specific focus would be assisted by a lot of the data that has already been gathered there.
All right, thank you. Thank you, Ms. Sykes. Any other council in support of the joint memorandum wish to speak at this point? All right. Thank you, Ms. Sykes, Mr. Benyon, Mr. Stone. We'll take a break, say 20 minutes, and resume at 12:15. Thank you. I join that. Not me. So I just said join.
you'll need to re-click on the icon at the bottom of the screen. Kia ora tātou.
Are we back with everyone, Sana? Kia ora koutou. Apologies for the slight delay. We were just ironing out a technical issue. All good? I'm going to call for submissions from Council on the scope issue. And if just bear with me, I have an order that I'll follow from the list. So if I could next hear, please, from Ms. Mason from Phoenix Law.
Good afternoon, sir. Submissions were made in document 3.1.81. And the first issue I'd like to address in terms of scope is the issue of the date. So I think that's one thing that we can narrow down quickly or easily. And the three or so options here are from the Crown saying that the only real data they have that's useful is from 2001 to 2019. So if the inquiry is about numbers and statistics, then that could be one way of limiting the scope. And I appreciate that the Tribunal has said from 1989 onwards. Now, obviously, that's one option because that is when the whole system was set up. And then, of course, there's the submissions that we had made around 2017 to 2020. And those submissions related to the overlap with the Manawahine inquiry. And Council acknowledges how His Honour started off this morning saying the matters are complex and in fact affect a lot of people in a very deeply personal way. And so what we tried to do was say, okay, for the purposes of the urgent inquiry, how can this be put into a basket? And then some of course, that's a decision for the Tribunal to make. However, in terms of working through this issue, I think focusing on the time period might be useful. In particular, this advice from the Crown that it's got information from 2001 to 2019, and that's readily available. And it may well be that if the Tribunal wants to continue and go from 1989 to 2001, that it be done in phases, because if we've, of course, already got a lot of data for 2001 to 2019, then that can be started with, or we can start with that. And then the other information that might take the Crown some more time to put together, for instance, from 1989 to 2001, can be done as a second tranche, because presumably these hearings will go on for some time. So that was one way of trying to work through the issues of scope, which are enormous. Council had made some submissions in this document, and they were set out in paragraphs 13 onwards. And one way that we had submitted in paragraph 27 of delineating the two, because of course it's a huge issue. It's as huge as the land issue, and some people say even more, and was to narrow the time period, and the other way was to narrow the Crown actors. And I know that that's not ideal, but it seems like we have to work through something, otherwise it's everything. And my friend Mr. Benyon referred to the statistics of the intergenerational aspect of how many of the mothers and fathers whose babies are being taken were themselves the unfortunate actors or players or victims or survivors of the state removal of them. So two of the things was narrowing the scope, and one was excluding the role of the DHB and the role of the police and the role of the others. Now, that becomes quite difficult in some ways, because when you look at the uplifts, and if we are going to look at why are these uplifts occurring and why so many of them, you can't really do that without looking at the role of the police and the role of the DHBs. Because as I understand, what happens is reports of concern are made from these agencies to Oranga Tamariki, and that just sets off a trail of events that seem to inevitably lead to the removal of children. And as my friend Ms. Sykes has said, and I don't think it's a contentious proposition to say that, the levels of racism within state institutions against Māori is quite high. So when you put all of those things together, you then build up a picture of exactly why it is that these uplifts are occurring. So having tried to separate those things out, I'm now making a submission that's very, very difficult to do that. So maybe it is just about trying to narrow the scope in terms of the time periods and looking at the statistics. So that's what I wanted to say about that proposal. And a lot has been submitted by Council on the interface with the Mana Wahine inquiry. And those can be taken as read, and I presume the tribunal will work through that. We'll just abide the decision of the tribunal unless there are questions on that particular issue.
All right, thank you, Ms. Mason. On the issue of the timeframes, and if I can just give this indication for your response and also for Council to follow. The Crown has also raised a question around the extent of the focus on the 1989 to the present, and raises the question about how wide that scope would be. This is at paragraph 22 of the Crown's memorandum of 13th of May, document 3.1.89. And the questions raised as to whether the tribunal envisages a more detailed inquiry into Crown acts and omissions from 1989 onwards with associated findings and recommendations. The latter would be a more significant undertaking, which may impact the proposed timing of the first contextual hearing. I just wanted to indicate that I think Ms. Sykes was right to point out that within the latest submission from the Crown, there is, at least it seems to us, the potential for some constructive engagement between Crown and Claimant Council around the extent to which some matters of context from 1989 up to the present can be broadly agreed. So I accept the point the Crown makes about the reliability of the data up to 2001, but the question that we would appreciate some further assistance on, primarily from Crown Council, is whether it's accepted that the fact of disparity, and a significant disparity, is still clear from 1989 to 2001 and beyond. In other words, is that a fair or reasonable inference that's available from the data, from the information that is accessible? If that broad proportionality is accepted as an established and ongoing trend from 1989. It doesn't necessarily require that we expend a great deal of our inquiry on trying to establish that and what the particular causes are beyond the evidential foundation for the context that I was discussing with Ms. Sykes, for example. So the extent to which those broad matters of context can be agreed by way of some form of agreed statement of facts or other technique is what we had in mind, which would then enable the focus of the hearings to be more on whether or not the more recent legislative changes from 2017 appropriately respond to the systemic issues. So, Ms. Mason, I'm not sure whether that helps or you want to say anything further at this point, but I just gave that indication to you and to Council to follow.
So yes, that is helpful, and I do think that if the Crown can come up with that, then that would solve a lot of the problem. And I do think the focus should be on more recent changes. So I have to also say, pointing to the Crown Memorandum at paragraph 19, where they talk about preparing a chronology of the key legislative policy and practice changes from 1989 to the present, would be very, very helpful, especially once it gets to 2001. So we can then compare the statistics that we have with the changes in policy and see whether there are any spikes, for instance, or whether practice or policy changes led to differences in the numbers of uplifts that occurred. So I think that would be helpful, and Council would be very happy to be on a group working with the Crown on that agreed statement of facts. Right. So the other thing, so that I wanted to make a submission on that adds to what was spoken about earlier this morning, is that perhaps it also would be useful if the Crown could look back at Puao Te Atatu, because I have a client, Mrs. Tedewhai Harawera, who was involved in the working groups on that. And perhaps the onus really should be on the Crown to explain what they did with that report, and why, as His Honour put it this morning, the practices that the report wrote against or said shouldn't be occurring have become embedded in the system. And that might be a useful point. Otherwise, we run the risk of just going through an exercise, getting to exactly the same recommendations and solutions as that Puao Te Atatu report, and then having no changes. So I wonder if the Crown could be asked to respond to that, and in terms of that report, what things were picked up and what things weren't, and more importantly, why they weren't. Are there some great obstacles in the Crown system that have led to the recommendations in that report not being picked up and incorporated into the system? So the other thing I'd really like to talk about and make submissions on is the proposal to have a stage 1 with experts and academics, and then a phase 2 with the more personal experiences of people. And to make submissions on really this Hastings case, and going back to that Hastings case, there is a lot of information available. And it's not really until you look at an actual real case and what happens and all the different players that you begin to see what the problems are in terms of treaty consistency in the whole system. And so I would submit that it would be useful still to have at least one or at least that case, because there already is a lot of information. And
Ms.
that
Mason, sorry to interrupt. Just on that point, you'll recall that our original proposal was to start with that case. In our more recent directions, in response to the concerns that have been raised by Crown Counsel about the family court proceedings, we had proposed to start with the broader focus and then move to the Hastings case when it was appropriate to do so. So at this point, as I indicated earlier, I'd be grateful if you could liaise with other counsel, including Crown Counsel, and Orpha Cassidy about the time and the circumstances in which it would be appropriate for the tribunal to hear from the parties involved in the Hastings case. And if that could be, at least in a preliminary way, the subject of further memoranda next week, at least to the extent you're able to give a possible time frame by which it might be appropriate for the tribunal to hear about that case, then that would be appreciated.
So yes, we'll do that. And we filed a memorandum setting out that they weren't asking for the tribunal to have their children returned, and that there were actually two separate jurisdictions. And so yes, as Your Honour pleases, we'll liaise with Counsel Assisting and Crown Counsel to talk through what can be done about that. But so the submission still really is that to look at statistics in the absence of real live case studies would not be ideal.
I take that point, and that was in part one of the reasons we had originally proposed to start with the Hastings case, and for the reasons that we had set out in our directions. I can understand that. The broader question of a timetable towards our first hearings is also something we will need to hear further from the parties after today. And in particular, we're going to need some further guidance after we've had our discussion today about what are realistic timetables for things that may be agreed, such as a chronology from Crown, and such as work towards an agreed statement of facts. So I'll say no more at this point about those, but we need to stage our procedure and our hearings with those in mind.
Yes, sir. So there was a further issue around scope and around the data, and that is that my clients have a particular interest in some of the things, some of the detail around the uplifts. And one of those things is that when you look at the statistics altogether, they paint a very different picture from when you then separate them out and look at the uplifts of newborn babies. And so any statistical information should be seen in that light. They have a request for the data to be separated out and to clearly show the newborns from the others. The other thing is a subset of that is the data around subsequent newborns, because there's a practice of if there's a newborn, if there is a child already in state care, of just sort of automatically a box ticking exercise of picking up or uplifting a subsequent baby.
All right. Can I just clarify the clarification on the data that you seek? Would you be able to perhaps specify in a memoranda next week, in light of the data that the Crown has made available, which sets need further particularisation of the kind you're describing?
Yes, sir, I can do that, because one is that the subsequent child, and the other is the number of without notice uplifts. So
All
those two things.
I'm conscious
which I'll
that, sorry to interrupt you, I'm conscious that some of the data and information released by the Children's Commissioner and what's likely to be in the Children's Commissioner's report, which we understand will be available in the not too distant future, may well respond to the newborn Pepe that you're alluding to. So we will be keeping an active eye on the availability of further information from the Children's Commissioner as well.
Yeah, thank you, sir. And it may well be that as part of the agreed statement of facts that agreed statistics or statistical data could be agreed. So the other submissions I have are not to do with scope, and if we're going to go into those later, then I could make those later. Those were the ones that I had on the scope of the inquiry.
Thank you. We'll leave that there because we'll come back to the other matters on the agenda after I've heard from all parties on scope.
Yeah, and so that I'd really like to make a sort of final one on the scope, and that is the claimants respectfully request that a thought be given to something that's urgent, that doesn't take too long, because in the latest budget there didn't seem to be much set aside for this sort of area. And in New Zealand's history, whenever there are moments of the proverbially tightening up the states or the country's belt, that it's the vulnerable that get left out. And the worry is that all these policy changes and all these budget allocations are being made, and this particular sector will miss out.
All right, thank you. Mr. Lyle?
Thank you.
Cool, sir. I have nothing in particular to add. We supported the joint memorandum of council dated 1st of April 2020, and I can confirm that we support the joint memorandum of council filed yesterday.
All right, thank you, Mr. Lyle. Ms. Smale?
Yes, sir. I filed a memorandum this morning around about 10 a.m. And the panel probably has not had a chance to look at
Great.
that.
Sorry, we haven't had a chance to look
briefly,
at that. Sorry, can you hear me? I'm just saying I have seen it come in, but we haven't had a chance to look at it.
So I just proposed to speak to solely to the issue of scope. In the memorandum, I set out that my client agrees with the proposals that the tribunal has set out in terms of scope, in relation to, first of all, trying to seek that initial clarification from the Crown about disparity in the takings, and that this is inconsistent with the treaty principles. And also that following on, it would seem that that's something along those lines should be relatively straightforward. Following on from that, we're in support of working on an agreed statement of facts. And we had suggested that that the Crown provide a first draft, and I think I saw something from the Crown along similar lines in terms of the chronology. I think if we can keep the agreed statement of facts initially to very, very much just the facts that wouldn't be contentious. For example, this is legislation, these are the policies, and in terms of outcomes, perhaps just the statistics that are available at any point in time from 1989 to the present, that would be useful, and it would be appropriate for the Crown to provide a first draft and I've proposed possible amount of time for that, and then a following up for the claimants and Crown to try and reach agreement or identify areas of disagreement. Also, in terms of scope, my client considers that the three main questions that the panel has posed for this inquiry are appropriate, and also that they usefully help to clarify the scope of the inquiry. The focus of the Māori organisations that my client has made the claim on behalf of is where are we today, and what can we do better in the future? So in terms of what's happened since any previous dates, since 1989 or 2001, it would be really a matter of evidence of explaining how we've got to today. So answering the first question that you've posed, and how and then looking at whether the recent changes would have made any positive difference, and what could be done in the future. So while I understand there may be a level of different levels of evidence available from the Crown, for example, at different periods, that would simply be factored into how you answer the question of the questions that have been posed. It doesn't necessarily mean that there needs to be a limiting of evidence that can be brought, or indeed that there needs to be a widening of scope of the inquiry. We simply work with the evidence that we have available, and if we can keep a focus on those three questions that the tribunal is posing, I actually think that they usefully help clarify scope of the inquiry. And those are the points that I wanted to add in terms of scope.
All right, thank you, Ms. Smale. And just I agree with you that what we had in mind in suggesting an agreed statement of facts, given that this is an urgent inquiry, was largely as you described, which is essentially a recital of what should be non-contentious matters of fact in terms of what the data shows and what the applicable legislation or policy was in the time period that we are proposing. So thank you for those submissions. Kia ora. Ms. Castle.
Thank you, sir. Nothing much further to add to my friends except to support a process whereby a chronology and agreed statement of facts is worked through between Crown and Claimant Counsel, which will assist with efficiency. Like Ms. Sykes noted earlier, our clients are concerned that scope without context could be detrimental to the inquiry, so that the exercise will be helpful. So.
All right. Thank you, Ms. Castle. Ms. Downs.
Tēnā koe, sir. I'm just in discussions with my staff, currently trying to seek clarification on the relationship between the issues identified by the tribunal initially when urgency was granted, the recent three issues also identified, and the discussion around the scope of the statement of facts. And perhaps if I could just put the question to you, sir, is the intention that there is a statement of facts in addition to the current issues, and that a statement of issues document will also be developed? Or is the statement of facts in addition to the existing questions, and therefore a statement of issues document will not need to be developed?
We had proposed something like an agreed statement of facts as a technique to try to record what I was just discussing with Ms. Smale, which was essentially non-contentious matters of fact that record what the parties consider to be the key relevant policies, legislative provisions, and the data that speak to our core issue, which is the disproportionality or the rising and disproportionate number of Tamariki Māori taken into state care. We had initially proposed the 1989 to the present time frame because that seemed to us a logical period, both because it originates out of the changes introduced by the legislation in response to Poau Te Atatu, and also responds to the phrasing of the issue we are given, which is under the auspices of Oranga Tamariki. Why has there been such a rising and disproportionate number of Tamariki Māori taken into state care? What we've endeavoured to do in the most recent directions is to suggest a possible way of focusing the inquiry based around that platform, and the focus would be, once that platform is laid and matters of context are the subject of evidence and hearing, the focus then becomes on whether the legislative changes from 2017 and the subsequent policy implementation that the Crown is implementing at the moment and going forward, the extent to which they do or do not meet the required tiriti standards. With all of that in mind, we haven't come to any view on whether a more detailed statement of issues would assist or would be required. I think some of that will depend on the extent to which Crown and Claimant Council can reach common ground on an agreed statement of facts or something similar.
In relation to the discussion then, I think that from our perspective there would be full support for the development of a statement of facts as well as a chronology. Still would like to clarify through the process how we finalise a statement of issues through. In terms of the chronology, I can advise that we've done a fair amount of work within our firm, and that could be used as a starting point for the chronology. I'm happy to provide that to the Crown and whatever committee is established or group is established to work on those documents. Would appreciate having input into those documents as well. In terms of the scope, sorry, sir?
Sorry, just before you carry on that point, thank you for that offer. Could you please provide any draft chronology or information of that kind to Crown Council, also to Council assisting the Tribunal, and we would ask that in the steps that follow today, Claimant and Crown Council liaise also with Council assisting about how these steps are advanced, and that may make more efficient the process from here. Thank you.
I'm happy to do that, sir. And I think we had filed in one of our earlier memoranda just the indication that the setting of timetables around these documents will provide some impetus and a way for some of these issues to emerge over what is and isn't agreed. At the moment, the discussion broadly sits across a range of submissions, but through a timetable process by the Tribunal, it will become clearer what is an agreement and what isn't. So we very much support that happening in the next few weeks.
Thank you.
Those are my our submissions on scope, sir.
Thank you, Ms. Downs. Ms. Hall, Mr. Rogers.
Can I speak now?
Yeah.
Kia ora, sir. Thank you. Before we begin, could I just ask our registrar to note that when I set out those on the call, I made some important omissions, if they could be included. The Te Teko cluster, sir, includes our most prestigious kaumātua Hemana Eroera, and with him the chairman of the Mātātua Māori Wardens, Mr. Alex. And I forgot completely to refer to the Otaki cluster, Dr. Hook and to Ms. Lynn Omati, and with them at the moment is Ms. Grace Hoyt, but she's there for Waikato District Māori Council. And the chair of the Raukawa District Council is Taihakure Diri, who's also on this call. So if those names could be included, I'd be grateful. And if I could just say that the New Zealand Māori Council does have some comments to make, and if we could just briefly say the initial concern of the council is that the items on the agenda at this stage don't seem to give a space in there for the free expression of the many Māori members of the New Zealand Māori Council out in the districts or to other Māori in the districts to say how they think this inquiry should proceed. And it's not been possible for the council to give notice of this concern earlier. We received the 7 May direction, sir, and in it, it has the 3 pivotal questions which have been identified by the tribunal. And these questions have now gone out to the 16 district councils. And it's only now, after they've had an opportunity to discuss the 3 questions, that I'm able to say to you here that the council is very firmly of the view that those 3 questions are the correct questions for this inquiry to ask. Now, if we can begin there and the questions themselves, our first point is that it follows then that the focus of the inquiry is not on individual cases of alleged bad practice. The task is not to find out who did wrong to whom. Individual cases are only relevant where they each illustrate a particular systemic failure. The second point is that it follows that the focus is on systemic issues that inform the 3 questions that have been asked. And the third is by way of illustration. In 1988, Puao Te Ata II completed the most transformative proposals ever put up in the area of childcare. But it did not need to examine particular cases. It realized that the problems were systemic and focus on individual anecdotal cases can result in piecemeal solutions. So we feel that a structural solution is required and that it is appropriate for this tribunal in an urgent situation to focus on those underlying systemic structural concerns. I can say this, sir, I am the sole survivor of the panel of Puao Te Ata II. And Mr. Neville Baker, who stood in for the Secretary, Tamariki, is the sole surviving member of the advisory panel. So we do have some considerable knowledge of the department from when the report was tabled. The council submits, sir, that there is difficulty in determining the structural issues because the people out in the field, and certainly the members of the New Zealand Māori Council, they don't know the inside story. They don't know what they don't know. But there is a group that do know, and that's the staff of Oranga Tamariki and the service providers to Oranga Tamariki. Now, they are very likely to know. And New Zealand Māori Council's position is that the tribunal should meet with that group very early in the inquiry. So, sir, the New Zealand Māori Council proposes that this panel begins the inquiry into what the problems are by first receiving submissions from Māori people ourselves on what we think the problems might be and our answers to the 3 questions you have posed. Ask the Māori people first. The second is to then receive submissions on those same questions from the social workers who are presently working in Oranga Tamariki, from past social workers who have served Oranga Tamariki, and from Māori service providers and others who have served in the area. There'll of course need to be certain confidentiality and anonymity protections provided, but we do think that this group is a very knowledgeable, pivotal group that can help inform the Māori public about what the issues are that are going wrong. And when this inquiry goes on, we think there's no difficulty in having counsel for the Crown present when the staff from Oranga Tamariki are questioned, 1 counsel for the claimants and a counsel to assist the tribunal. But when all of these 2 groups have been heard, and by submitting questions to the Crown and requests for documents, what we feel is that that will place this tribunal in a position to then produce a report from your own inquiries, and that report becomes the basis upon which you commence your inquiry. And if you do it that way, you will carry Māori people with you through the whole of the inquiry. So if we can just illustrate very, very briefly, I won't take much longer. If I can just put it this way, in just the very short time that the District Māori Councils have had to consider your questions, they have come back with these sort of thoughts. That Oranga Tamariki employs business models based on popular business methodology, and that the staff have to work to business criteria. They are assessed according to how they comply with given targets, and it means they have to take shortcuts to keep the deadlines. Now, many of those employed to manage the model, we're told, are also from overseas, and that they're not even knowledgeable of how things, many don't speak English as a first language. The model is not based on a Māori social structure, it's based on a foreign model. And in Puao Te Atatu, it envisaged an army of community workers operating through Māori organisations. And that is what Māori want, that is what the Māori Council members want, and you'll hear from them. They want an army of Māori workers, and they want them appointed from the communities from whence the victim and the offenders come. And that they may still have, that might still be an objective of Oranga Tamariki, but no one's quite clear. What we do know, sir, is that very important and helpful organisations like Open Home Foundation and the Salvation Army do manage to fit into the criteria where Māori groupings don't. So our people are not trained into the capability criteria areas, and the result is that Māori people ourselves, we're not in control of the management of our own children. And then there are other issues that we've heard that have come in. For example, there are whānau looking after the children of other whānau members, but they can't get funding assistance because the child is not a ward of the state. Now, in order to become a ward of the state, to get funding, you have to do something. And what we're trying to point out is that we've heard from many around the country that that's a real issue. Funding won't flow unless you're made a ward of the state. And so what we're saying to you, sir, is that if these matters are dealt with in this way, you can draw from the strengths of the people themselves to help focus the scope of the inquiry in a way which will carry Māori from around the country with you. And in the end, these are the children of Māori. And we feel that the Māori voice should be heard before you proceed on with hearing from the important submissions of legal counsel and others. That's our submission, sir.
All right, thank you, Ms. Hall. I would just, as I've indicated to other council, if you're able to develop a number of those proposals further in submissions to follow today's conference, that would be helpful. And in particular, I'd direct you to our most recent directions and the one prior, where we first proposed what we call context hearings. And we had listed provisionally a number of parties who we felt may be able to assist us with some of these systemic issues. So just taking your point that we should initially hear from the Māori voice, if you have particular individuals or organisations that you believe could assist us, we would be pleased to hear those proposals. And we also take the point that case studies should speak to the systemic problems, and in our earlier directions we had indicated that the Hastings case seems to us to be one such illustration, partly because there is a lot more information about that case available than would normally be the case. So I'll leave it there, but thank you for your submissions.
Sir, before I leave, if I could just put this to you, your questions were canvassed carefully amongst the district councils who are watching this exchange. They are aware that it's a privilege for us to be able to have them online and for them to contribute. They have a lot to say to this. I can give you my assurance, they will not ramble, they will stick to the questions and the points, and that if you could make a space for the clusters that I raised with you to have an opportunity to have input in the afternoon session, that would be, I believe, a very beneficial thing, sir, for your panel. There are serious experts sitting out in these clusters, and they have a lot to contribute. And behind them come their Māori committees and the communities that they represent. So thank you, sir.
Thank you, Ms. Hall. I have read the information you filed and the profiles. I acknowledge the collective expertise that you have brought before us today, and thank you for that. I would like to finish hearing from Council and from Crown on the scope question, and after our lunch break we'll come to some of the more practical matters around the context hearings and timeframes, and if there's time available we'll certainly try to accommodate hearing some brief submissions from the representatives present. Thank you.
Thank you.
Ms. Napo Lipscomb.
Tēnā koe, Your Honour, I don't have anything further to contribute at this stage in terms of scope, but I did file a memorandum of council dated the 20th of March, sir, where I just raised the issue of inclusion of the claimants that I represent, and I know Your Honour has already referenced that you will address that later on. So unless there's anything that I can assist the tribunal with at this point, I don't propose I carry on further making any further submissions.
Thank you, Ms. Napo Lipscomb. Ms. Hardy.
Thank you, sir. Very much appreciate the comments made by Claimant Council and by Your Honour in terms of moving us to a focused kind of inquiry. The Crown, of course, has set out its position in the written memorandum of the 13th of May, to which Your Honour has referred, as have Crown Counsel. just to perhaps move backwards a little first before going forwards, what the Crown has been informed by to some extent has been the granting of urgency by the Chief Judge, and that's in the classic urgency framing of conceiving a significant prejudice from pending or current Crown policy. So that planted the inquiry clearly in the present and looking forward for advice findings from the tribunal about the future. And that, I guess, chimes with Ms. Mason's comment about there needs to be a degree of pace to this inquiry. We've set out that we...
Ms. Hardy?
We think, yes.
Sorry to interrupt. You're, at least on the screen that I have, you're addressing, or the screen shot of you is to your right, maybe? That way,
Is
yes.
Okay, I'm set up with a laptop with a camera and a large screen on my desk. So
you're looking direct onto us now.
Okay. Unfortunately, I can't see you when I do that.
That's probably
so
a blessing.
Shift between, if that's all right, Your Honour. That's the explanation for the angle.
All right.
Okay. So Your Honour, as is apparent from the written material, the Crown's stance is a focus on current legislation, policies, their application, and part of the reasoning for that is relatively recent reforms looking back in 2017. So that's the justification, as well as the very nature of a granting of an urgent application. But to help get there, we've committed to some of the points that Claimant Counsel and Your Honour have raised. To get there, we've made the treaty statement in our memorandum. We've agreed on the disparity information, at least going back the 20 years that we have the data for, with a slight commentary on the Len Cook evidence. But that's agreed. We're happy to work on a chronology or statement of facts as offered in the memorandum, which, as Your Honour noted, would be a non-contentious rehearsal of the background to getting us to the present day. And in that context, our hope is that the importance of the issues and the pace that really was being set by the granting of urgency could be met more fully by that cooperative process. In terms of case studies, I think the comments that Council have made have been important from both sides. One, the importance of having some flesh to the bones of an inquiry, but I think Ms. Hall's commentary about pitching this at a systemic level is very important to be able to inform assessment and findings. So one suggestion is that the issue of case studies and their approach to them might be best made once we've got through the first hurdle of whether it's accepted that we're in the contemporary space through the steps of chronology, facts, and the material that the Crown has already filed. And then I think a better overview of the impact of case studies could be made. And just to move that along, Your Honour will recall that the Crown drafted a confidentiality provision as well, a statement that was circulated to Council, so that could be also part of the mix in relation to the case study issue. So really, Your Honour, it's just, in terms of scope, it's to reiterate that the Crown strongly supports something that focuses on contemporary practice, the contemporary legislation, and that if the tribunal were to look at that based on the acknowledgements that the Crown has made largely in that most recent memorandum we filed, it's our submission that that would be the most fruitful way forward. And Your Honour, we'd say that that is reinforced by the number of other inquiries that are on foot that the Chief Judge referred to in his urgency and which Your Honour has just referred to, and which will doubtless inform this inquiry should they be available.
Thank you. You may recall the discussion I had with Mr. Benyon about paragraph 22 of your memorandum, and that's document 3.1.89. And this goes to your submissions about how we lay a platform to arrive at a contemporary focus. And just to put it in very high level terms, the premise that seems to us to be part of the issue we have been given for urgent inquiry, and also a fairly consistent premise in the various claims that have been put before us, is that Po'o to Atatu was a landmark inquiry and report, and there was optimism that changes introduced following that report in 1989 would promote a significant change. What has happened since then appears to be a consistent trend of rising in disproportionate numbers of Tamariki Māori coming into state care. So what we had in mind was if that broad context is broadly accepted by the Crown, and the policy and legislative framework from that time can be laid out, the question then becomes is why, notwithstanding those changes and the policy directives and discretions that they allowed, have we arrived at this situation which the Crown acknowledges is inequitable and needs to be addressed. So there's a balance, and I just wondered if you're able to make any further submissions on that outline I've given you and how we might approach that.
Well, the Crown submission on that is to, again, retain the focus on the present and the future. That was and is accepted by the Crown as being a significant report. Others followed, including the analysis that preceded the 2017 reforms. So, Your Honour, I would see, given the need for this to satisfy an urgent inquiry and to move forward, a narrative in the chronology that we're proposing as an agreed backdrop of facts, the lead up to the current reforms, the acknowledgement of disparity and that has persisted, is a sufficient basis for the forward focus. In my submission, a reference back to try to explore more complex historical matters would be a different kind of an inquiry.
All right. Is it accepted that the trend of disproportionate numbers of Tamariki Māori is established and consistent from 1989 1989 to the present, notwithstanding the fact that more comprehensive data is not available until around 2001?
Your Honour, I don't have that as an instruction, but I can. That's a point that if it assists the tribunal in framing the inquiry, then I can certainly get a clear statement from the Crown on that point. There's certainly no dispute that there's been ongoing and persistent disparity. I think the evidence goes to the last 20 years, but
All right.
A further statement can be made, Your Honour.
That would be helpful. It seems to us from the information that is available that that's at the very least a reasonable inference to draw, and if so, can form part of the agreed context. I think the more difficult issue is the question of why there is an established trend of this kind. And I just want to highlight a point that panel member Kim Ngarimu has raised, and that's that in addition to an agreed statement of facts or something similar, it may also be helpful for any particular points of disagreement between Crown and claimants to also be recorded or highlighted. And do you have a view on that?
Well, Your Honour, I took it from your statement earlier that what the tribunal was looking for was a non-contentious set of facts and chronology that could be the basics for the first step. So whether once the parties have done that, and I gather some drafting has already been done by claimant counsel, then perhaps it's a live question about whether that throws up points of disagreement or not. I was seeing it, Your Honour, as more your description of a non-contentious but sturdy factual background for the current inquiry.
So that we think should be achievable in the way we've described, but if in the course of that dialogue significant differences emerge, it may be that that they ought to be brought to our attention. At this point, we don't see the need for something like a formal statement of issues, but we need to keep an open mind at this point to see how progress can be made on setting what we're describing as a framework from which we can try to attempt a focus on the more immediate contemporary question from 2017 forward. So, Ms. Hardy, just a couple of questions on the memorandum. In paragraph 11, you record that the causes of the inequity are complex, and it's been accepted that a significant contributing factor has been the ongoing effect of historical injustices on iwi, hapu and whānau. Can I just clarify as to where it's been accepted? Are we referring to historical settlements or the like?
That was the context that the Crown had in mind in that acknowledgement.
All right. And at paragraph 14, you've indicated a willingness to consider making further acknowledgements as the inquiry progresses. On that point, and on the the question of work towards an agreed statement of facts and the like, in submissions next week, would you be able, please, to clarify as best you can what the anticipated timeframes would look like for those steps?
I can do, sir. The comment was really relating to the evolution of the claim and the hearing of evidence, rather than something that would happen outside of that context. It was really just a point of keeping an open mind and not waiting until the end before making any further statement. But really it would be a question of the tribunal finally shaping the inquiry, the evidence coming in, and the Crown reflecting on that along the way.
All right.
I'm not sure I can be more precise about timing than that, sir.
Thank you. All right, do you have anything further, Ms. Hardy, at this point?
Not on the issue of scope, no, sir.
Thank you. We'll break now for lunch. What time would you? 15:15.
Lunch is coming back at 2:20.
All right, we'll resume at 2:20. Thank you, everybody.
Oh, no.
I join this. I click. Excuse me. I close back over into you. We're all good. Kia ora, no koutou. Just before we start on the second main topic, which is the contextual hearings or proposed contextual hearings, I just want to make a few comments for the assistance of Council. We've indicated that we've got two dates that are available, the 30th and the 31st of July. Whether those dates remain suitable will, to a large degree, depend upon what progress is possible in the interim around confirmation of the inquiry participants, and I'm confident, working with staff, we can resolve that in the relatively near term. Progress on the agreed statement of facts or similar document, a confidentiality protocol, if that can be advanced or substantially agreed between the parties, and also whether there are issues of disclosure that might need to be addressed and resolved prior to commencing what we have described as contextual hearings. I simply note those matters and ask Council to address them so far as they're able in submissions this afternoon, and if not, as matters for further submission next week. I should also just briefly indicate that in terms of our forward planning, and particularly around dates, the availability of the panel will be a challenge. I'm privileged to sit with the esteemed members, and because of their collective skills, they are in demand, and it is difficult to find dates, particularly a significant block of time where all the panels available. So depending upon where we get to at the end of next week around a likely time frame towards commencement of hearings, I may seek from the chairperson possibly further appointments to the panel in order to assist us meet the requirements of the inquiry itself, and I just flag that for parties' information. So, just with those comments in mind, I'd like to again start with Mr. Stone, Council, on the joint memorandum. Kia ora.
Ms. Catherine Laonga is going to be addressing the tribunal in respect of the contextual hearings, but in terms of those 3 points that Your Honour's raised, the statement of facts, who's in, and the confidentiality and disclosure issues, I contacted Counsel for the Crown, and the intention is there to work with the Crown to draft that statement of facts. So who's in, well, we're in Your Honour's hands and on that one. And in terms of the confidentiality, there's been 2 memos filed so far, one by Ms Mason and the Crown. I don't have any issues there, sir. So I'll pass things to Ms Laonga.
Kia ora, thank you.
Tēnā koe, sir.
Kia ora.
So I just note this morning your discussion around the contextual hearings and the possibility of them being extended out to more than 2 days, as well as moving towards possibly calling them substantial hearings. So I'll just highlight that right from the beginning, since we filed our first memo on contextual hearings on the 20th of March, and then again on the 1st of April, the claimants have always it's been their preference to proceed to substantial hearings as full hearings, and that hasn't changed. And so with your discussion this morning, that would align more with what our claimants were suggesting. So we thank you for that this morning. And I would just refer to our latest joint memorandum of council of the 14th of May. In that paragraph 15 there, we've just highlighted some of our previous concerns with the earlier discussions around how the contextual hearings were going to be run. So one of the main ones there at paragraph A, we have a concern about having to recall witnesses more than once potentially.
All right, just
so,
could I have that paragraph number again, please?
15A, Your Honour.
And this is document 3.1.90.
Correct.
Yes, I have it. Thank you.
Yes, so in our previous memorandum, we did give further submissions, but these are the key ones in our most recent one. So we do have concerns about the need to recall witnesses. Main issue there being that we don't want to subject them twice to any further prejudice and the difficulties that many witnesses will experience in having to retell their stories. So that's one of the concerns we have there.
All right.
There's a whole list of them there. Yes. The other one of the key ones being, depending on how these contextual or substantive hearings run, that funding be available for the witnesses to attend, whether that's in person or some assistance with the AVR connections, if that's how we're going to run it, and just ensuring that the claimants have the ability to attend and be part of this process as well. So those are our main concerns, Your Honour, there. If we move down to paragraph 17, we've got our submissions there regarding the key procedures which should be followed for the contextual hearing. So the main one being that any evidence is submitted in writing so that it can be appropriately tested by the tribunal and claimant and Crown Counsel alike. That was something that was missing from the earlier suggestions around how they would, how the contextual hearings would be run. So ensuring that we do have the opportunity to provide evidence in writing, and then also some restrictions and also the option to be able to cross-examine any evidence for contextual hearings. That's something that we would like the opportunity to do, but also to have appropriate restrictions in place, particularly for tangata whenua witnesses who will be appearing, to ensure that any cross-examination is done in a mana-enhancing way, that they're not going to, again, be subject to further prejudice. So those are our main submissions around the contextual hearings at this time. We did discuss timeframes, and again, like Your Honour has already pointed out, a lot of this will be dependent on progress with the agreed statement of facts, the scope of the inquiry. But we have previously submitted on some potential witnesses, and we've listed those people again at paragraph 18 of our joint memorandum. And there's further witnesses who have informed council that they are willing and available, subject, of course, to the scope and their own time availability with COVID-19 restrictions as well. But there is a whole pool of experts and witnesses who are willing to come forward to assist the tribunal, and we would be wanting to make more submissions on suitable witnesses.
All right. Kia ora, Ms. Luaga. Just to clarify one issue you raised concerning funding, is that a legal services issue?
Yes, potentially, Your Honour, that would be a legal services issue. But whether the Crown might be able to assist in any way, that's a discussion that we would be willing to have. But at the moment, it is, from what I understand, a legal services issue.
And that raises restrictions on support for claimants to attend hearings?
That's correct, and even just support to prepare the evidence for some witnesses who might live rurally and don't have connections to internet and telephone services. Their ability to travel to meet with counsel can sometimes be an issue.
All right. Our preference ideally would be to have hearings ultimately kanohi ki te kanohi in the usual way. At the moment, of course, we don't know when that is going to be possible and how that aligns with the timetable we're trying to develop. And just to respond to your submissions on the substantive nature of what we've called context hearings versus the first proposal, which was a slightly different proposal. Just to be clear, the panel's thinking is that we agree with the submissions made that it would be preferable to start in a more conventional way with evidence and submissions in the more broadly in the way you have outlined, which is written briefs and subject to a procedure that would allow for the appropriate testing of evidence. Now that in turn depends upon the rate at which we can progress the foundation for that stage of inquiry, which is really around the agreed statement and confirmation of the scope. So those are matters that we would like to hear further from parties and council next week. The other proposal you had raised was the appointment of an independent counsel who would take on a role potentially in the proceedings to carry out on behalf of claimant counsel questioning or cross-examination. The funding for such a role, did you have any idea as to where that funding would come from?
Our experience from previous inquiries where we've used that sort of role is that counsel will agree to appoint a lead counsel for the role, and then they go about undertaking that task. From what I understand, most of the time we do seek from legal aid the position to almost coordinate in a way.
All
and
right.
So legal aid are aware that we would be doing this on behalf of a number of claimants. And so usually in the past that's how we've handled it, but other counsel might have had other experiences.
I'm aware of the coordinating counsel role, but the way you had phrased it in the submission was independent counsel, which I took to mean appointment of someone outside current claimant counsel. Am I misunderstanding that?
That wasn't my understanding, but that may have been, I'm not sure, you may need to address any of the other counsel if that's what their intention was, but that wasn't my understanding of how we raised it. No. Independent, I thought it would be independent within the counsel who are already participating, but I could be wrong because that might have been something else that someone else wanted more.
All right, no, I understand your submission, thank you. Has there been discussion amongst council about who might perform that role? Or is that still to be developed?
Well, it's very much going to be dependent on who the witnesses are that are being called, and then we would discuss it from there as to who's most appropriate. So it would also come down to availability of various counsel, depending on whether they have their own witnesses appearing in the contextual hearing, so that might impact on their ability to take a lead role, but it is something that we're all willing to discuss and develop further as we know more.
Thank you. Outside of the various witnesses proposed by yourselves and other counsel, it's possible the tribunal may also identify and call for evidence from a number of individuals or organisations. To the extent that they are not represented by counsel currently before this inquiry, we would envisage possibly our counsel assisting, leading those witnesses if appropriate. Do you have any submissions on that procedure?
We did raise some issues in our two previous memorandum of counsel. They're referenced as 3.1.75 and 3.1.82. So they're from the 20th of March and the 1st of April. And so we did have some initial concerns with just the role of council assisting and how that will operate in practice. So we haven't actually received further information on how that's going to roll out. So those concerns from those memorandum of council may still arise, and my friend Ms Sykes would most likely have some submissions on that aspect, Your Honour.
All right. Thank you very much. And just in terms of other council supporting the joint memorandum, Ms Sykes, did you wish to add anything?
Well, yes, sir. Our experience in the Royal Commission, where there's been independent counsel appointed from within the Commission to then lead our witnesses, has not been a good one. My witness have actually objected to that kind of process because it's taken a long time where you've been an abused state board, for example, who've had your children taken for you recently, to build trust and confidence in your own counsel, then to have to share that story with an independent counsel who they will have a limited time to ensure that they properly have support. It's really the way they're supported in the testimony. So we have some concerns. Our experience in the Royal Commission, I think I speak frankly for all of us here that are in there, has not been good where those witnesses are Māori.
All right, Ms Sykes, perhaps if I could just clarify our thinking at this stage. For those witnesses who appear in what we're calling these initial or context hearings who are represented by counsel, we agree that it would be preferable that they be led by the counsel involved. We also think it's a good idea, wherever possible, that written briefs be prepared. The role for independent counsel in this space would be limited to perhaps those organisations or witnesses who the tribunal might call, using our inquisitorial function, who may not actually be represented by any counsel before the inquiry.
And I don't have a problem with that. I think Justice Fogarty did that in the original fisheries claim, sir. I anticipate that would be appropriate completely here, and that person would be funded by the tribunal's own resources. Can I say that as a generic issue or a substantive underpinning issue, the access to resources and the way that has impacted to the disproportionate detriment of Māori and iwi and hapu is a key issue of a systemic kind. And in the family court and in the whānau family group conferencing processes, one of our key issues is questions of resourcing all the way around. Sadly, it's even reflected in this process. So we've been very careful, having regard to the current legal services policy, to try and work within the frames of that policy, but also sensitive to the need that, you know, this is not like the normal court cross-examination process. There needs to be sensitivity. So we've suggested senior counsel, not necessarily the same one. So when we said independent, sir, for cross-examination, it might be somebody who's not leading that person, or who's somebody, you know, that was our suggestion for any cross-examination that may, it was in that context. So they would be led by counsel and examiner-in-chief. If there was leave granted by the tribunal for that person to be cross-examined, then only one independent counsel would do that per witness, to minimise trauma to that witness, but also, I think, to recognise how we need to manaki the storytelling that is coming from those witnesses, to highlight the systemic issues that are at stake. And one of them, of course, is the lack of support for witnesses in the family group conferencing, in the uplift process when the police arrive. So that's, you know, it's all linked. So.
All right, thank you, Ms Sykes.
The only other matter that I think we also wasn't highlighted by my friend. Can I say we're also promoting Ms Leoga as our coordinating counsel. She's kept very strident counsel like myself and Mr. Benyon under control. I think she'll do a great job going forward for all of us, sir. One of the key issues that we have in terms of processes, we would like questions in writing before the person is giving evidence, after we've filed the briefs, so that, you know, people aren't put on the spot if there are particular issues that are raises the credibility of decisions that are made.
And that's questions in writing from the Crown and any other party?
Yes,
or primarily the Crown?
That would be the only, and that is to try and at least prepare people giving sensitive evidence what they're likely to face if they're going to face anything. They could do that viva voce, they don't need to have the replies in writing, sir, but we would like some set questions. We don't want people intimidated by the fact of that. And I say that for my claimants, many of whom are illiterate.
Right. It may be that in a number of instances, the Crown, for example, may not have questions of witnesses of that nature. And I don't know at this point whether any other party, any other claimant party might wish to question such a witness. If that arises, do you envisage such a process of written questions being applicable to any party seeking leave to cross-examine?
It would be helpful, sir, for the reasons I've identified. It's about minimising stress, and so they don't come in blind. We would not expect that from the tribunal. Can I be frank? It's just Crown and other participating counsel.
All right, thank you, Ms. Sykes.
I don't have anything else. I think that's all we wanted to cover in our memo, sir.
All right, kia ora. Mr. Benyon, did you have anything to add?
No, nothing further, sir.
Thank you. Dr. Gilling?
Sorry for the delay. Things are not responding promptly. Thank you for the opportunity, sir. No, I have nothing further to add to what my friends have already put forward, and also, of course, what was in the joint memorandum.
Thank you. And were there any other counsel supporting the joint memorandum who wished to make a submission at this point? No, thank you. All right, Ms. Mason.
So I'll refer to my memorandum dated 23rd March, which is 3.1.81. And your previous request that the issues with the Hastings case be discussed with counsel assisting the tribunal and Crown counsel, and subject to working all of those matters out, some proposals at paragraph 6, 7, 8, 9 in relation to the Hastings case. There are a number of people who are involved in that case who have publicly said they won't be involved in any other inquiry because they would wait for the tribunal inquiry. And those people are the whānau and the mother, and one of the midwives, Miss Rebecca Ormsby, Des Ratimer, who's the kaumātua, and the kahungunu iwi representative of the whānau, as well as the chair of District Māori Council. There was a councillor, Henare O'Keefe, and now he's the Flaxmere councillor on the Hastings District Council, and fostered 200 children that area, and he was involved in all of this. So those people, it was suggested with a contextual hearing, appear as a panel. And what was suggested in terms of the format, that a summary of the case is presented by counsel before the panel appears, and that there be short overview statements to focus on the issues which were relevant to the inquiry, and then fuller briefs of evidence would be filed for the purposes of the substantive hearings. And it may well be that those briefs for the whānau anyway could be taken as read.
Right, just Ms.
Mr.
Mason,
Raj,
just on that point, you would have heard the discussion I've just been having with Council about written briefs in the lead up to what we're calling context hearings. The proposals that you're making could accommodate that also?
Yes, sir. Yeah.
All right.
So just to be very, very clear, they have ongoing family court issues, but those issues wouldn't be the subject of this. This would specifically be about policies in relation to uplift.
Yes, I have understood your submissions in that respect. And just in terms of the information in the public domain about the Hastings case, which of course includes the TV documentary aired, I think, in May last year. I was going to propose that that be added to the record of inquiry and assume from your clients there is no objection to that?
No, sir, there wouldn't be any objection at all.
All right.
So then in paragraph 9 there, Mr. Ratimer had proposed that Te Aranga Marae could host, and of course that would be subject to COVID-19 safety measures, and then Mr. Ratimer could liaise and organise all of that. And the claimants in the previous memorandum that was filed last week, somewhere over here, in response to the Crown's concerns about any health and safety matters that may arise, Mr. Ratimer also, and the whānau, and Mr. O'Keefe, who's a lead member in that community and a councillor, would be very happy to work together with the Crown to ensure that any risks of any events occurring like that are minimised.
Thank you. With regard, sorry, Ms. Mason, just with regard to that, I'd propose that you advance discussions with the Crown about those range of concerns and advise Council assisting of the outcome of those discussions and any matters that may need further direction from the Tribunal following those discussions, please.
Yes, sir, we'll do that. So in relation to the discussions about cross-examination, I noticed that the joint memorandum was to do with cross-examination of tangata whenua parties or witnesses. So the proposal was that any tangata whenua witnesses cross-examined by other claimant counsel, that a lead counsel would be nominated. But so you might not have seen, there was a submission by my friend Ms. Smale this morning, and she says that claimant witnesses shouldn't be cross-examined by counsel for other claimants or interested parties unless granted leave by the tribunal, and says our experience is that this is increasingly common practice, increases hearing time but does not add clarity. Counsel supports that, and if there are questions from other claimant counsel, that they be put to the witness, like Ms. Sykes has said, in writing. The preference is that they not be cross-examined at all, and that if they have to be, that leave is sought from the tribunal, and that there isn't a lead counsel because people have different issues that they might want to cross-examine on, but that generally that should be discouraged, that the cross-examination should really be from the Crown, and the cross-examination from claimant counsel should be of Crown witnesses and not of other claimant witnesses.
Yes, I agree with that, and can confirm that we wouldn't expect cross-examination from claimant counsel of other claimant witnesses. Any such requests would need to be made and subject to leave, so those procedures we envisage would certainly be in place. There is a distinction, of course, between witnesses who are giving sensitive evidence of personal experience and witnesses giving evidence of their professional experience in the field, social workers, midwives, and other witnesses of that nature. The procedure broadly, we would follow a similar procedure that requests for leave to cross-examine on the part of claimant counsel be made, but we're certainly alive to the need to tread with great care as to how any witness before us who is speaking to sensitive personal experiences, that we are very careful not to be the cause of any further trauma by reason of our process. So do you have any further submissions on the approach to the contextual hearings?
So that just the ones that we had set out in our briefs, and that is that they just be short statements given. It was an opportunity for the tribunal to talk to certain key people and to help to refine the scope and the issues, and that they be followed by substantive hearings with the substantive pieces to come later. But in terms of the cross-examination of witnesses at the contextual hearings, if it's whānau, if it's, say, for instance, the Hastings whānau, counsel will be reluctant to agree to any counsel cross-examining. That wouldn't be fair. But in terms of cross-examining or questioning other people who were academics, cross-examination should be available to counsel for that, and leave should be sought.
Ms. Mason, the proposal that's been evolving and we're describing as contextual hearings, and particularly in relation to the Hastings case, is moving closer to what could be described as a substantive hearing in its own right. So we're not necessarily looking at a two-step process, and if we're able, in terms of the timeframes and resolving any issues concerning the overlap or not with the family court jurisdiction, we may be proposing to proceed to hear from your clients and others involved in that particular case as part of the initial round of hearings. And so that would, just in light of what you've been submitting, imply that we may not be looking then at a second stage for more detailed evidence, that we would look to do it on one occasion early in the commencement stage of this inquiry. And if that's achievable in terms of the process and timelines we set, do you see any issues or concerns?
No, sir, that would be achievable within the timelines. We have all the information that we need. This case is a year old, and so that would be achievable, subject, of course, to the COVID-19 restrictions. But, sir, in the recent memorandum I filed, the Crown party, so the Oranga Tamariki party, is having discussions with the whānau and the whānau advocates around a transfer of certain powers and functions to the local whānau ora provider. And so we would want to reserve an ability to be able to file any evidence later that would be relevant to what the remedies are that the clients seek, which is a transfer of powers and functions. So an addendum of evidence later, not necessarily from the whānau, but from these District Māori Council claimants.
All right, thank you for that indication.
And then, so we had set out in paragraph 33 on page 10, the witnesses that we intend on calling. And we were looking at, and as a part of phase 2, if it's going to be in phases, 25 briefs of evidence that would be case studies. And the point of the case studies is to show a pattern and thereby establish with evidence what the systemic issues are. It's taken some time to get Official Information Act, the files of these people or these witnesses, and we have most of them already, but for the remaining ones, I think it would be helpful if the Crown could prioritise the release of the information, because that sometimes has taken over 5 months. Obviously, there'd have to be confidentiality issues worked through. And just going through the other item.
Sorry, Ms. Mason, just before you move on to that point, in relation to the case studies, a number of council this morning have spoken to this idea and include submissions that the tribunal must not lose sight of the fact that there's a national systemic issues at play. What we had indicated in the earlier, my apologies, we may not have indicated in directions, but what we had in mind in response to one of the proposals by Claimant Council was that those council who wish to put forward case studies as indicative of particular systemic issues liaise with council assisting so that there could be a degree of coordination and oversight as to the range of case studies that are put forward. And I'm just seeking your response to that procedure as a way of also assisting with inquiry planning so that we are able to try and achieve a representative spread of case studies that we may look to for a fair representation of what claimants are asserting are systemic issues.
So council would be very happy to work with council assisting. The briefs of evidence that we've already started collating we think do represent a range of different issues. And I suppose that in that process of working with council assisting, she could identify which ones would be most useful for the tribunal. And then I had proposed in my submissions that the tribunal might not want to hear from everyone, but there might be some that are more representative than others that could be heard, and others would be happy to have their evidence just put on the record and taken as read unless there were questions. But so with the ones that we've been collecting, and this has been a process that's been going on for a while, it's taken a long time to get files for some of them. And if council assisting thought that there were certain ones of those that would be more helpful than others, then certainly those would be highlighted, and would be very happy to do that.
Thank you. The issue, of course, for the tribunal is that our hearing time is ultimately something of a scarce commodity. So we will look to parties for a degree of cooperation, if possible, as to how we allocate that time, and without in any way diminishing the importance of all of the evidence that may be put before us. It may not be possible for us to hear individually from all of the whānau who wish to bring their experiences before us. So we would look to you, Ms. Mason, and other counsel to work with counsel assisting, and to see whether a suitable range of case studies that could be the subject of hearing as well as entry on the record might be agreed with appropriate arrangements around confidentiality and hearing processes. And Ms. Mason, just on that point, I know that you have raised the question of assistance with counselling or support for witnesses, and I think you're essentially seeking an indication from the Crown as to whether they'd be prepared to help in that regard.
Yes, sir. One of the issues that has arisen is that people might have just not, or tried hard not to remember these events, and then the very process of getting evidence of traumatized claimants or clients raises all these ethical issues. And what I've been told by people who have had some counselling is that the counselling that is provided by the Crown, primarily through Oranga, is limited. So there's a fixed number of counselling sessions they have, and they say we just get to a position where we're starting to feel happy about things, and then it stops, and that's worse than not having any counselling at all. So we wanted to just say, and I personally wanted to say that it's very difficult, and I felt an ethical responsibility as counsel to raise this issue so that people aren't being put through reliving or being re-traumatized by events that were initially very traumatizing for them.
Thank you. I just missed your reference to the current service available, which is what you were saying was incomplete. That's through what agency?
So that's through Oranga Tamariki.
Thank you.
And the other issue about that lines up with the remedies would be that a number of my clients anyway are much happier dealing with the local whānau provider. And I wondered if my friend Ms. Mail, with the clients that she has, could be involved in that discussion with the Crown about the provision of that service, because there is a Māori, national Māori provider out there who could well be responsible for administering something like this.
All right, thank you.
And so just on the confidentiality protocol, I wonder if counsel assisting the tribunal could be involved in that discussion, because there has been a version that we provided and then a version that the Crown provided. I consider that most of the issues of contention between us have disappeared, because they were related to whether the original statements of claim were just kept off the record, or whether two versions were filed. And now that matter's been resolved and two versions have been filed. So I don't think that the difficulties that we had with the Crown exist anymore. And it really would be helpful to have Ms. Cassidy's opinion on any protocol.
Thank you. Could I ask you please to include that in the matters you discuss with both Crown Counsel and Ms. Cassidy, possibly with a view to reporting back next week on what, if anything, remains outstanding?
Yes, sir.
Thank you.
And so then the next lot of evidence was, we estimate, about 20 claimant briefs of evidence. And so take your note that you won't necessarily be hearing from everyone depending on time, and the time allocated has to be fair to other claimants as well. And so we would be looking to just have those persons who are necessary. And then again, so my friend Ms. Smale, who I'm sure will give submissions later, she's proposed some measures around restricting time for witnesses to just brief statements and then being available for questions. And she proposes a number of other measures which could be looked at. And then we had two expert witnesses, and one was Professor Mark Finnegan, who is a former dean at the University of Ohio Law faculty and has also written countless books on family law, is also an international expert in this field. And then Dr. Diane Korpua, who is a Māori psychiatrist who specializes in mahi a atua, and she has a framework specifically for this area.
All right, thank you, Ms. Mason.
And then we've just said that
yes.
we expect a full week of hearing time, but of course it'll be subject.
You can take the written submission as read. So it's really just if there are any other matters you need to raise in light of the comments I made at the commencement of the session.
So no, there was no other ones, except we'd like to add the disclosure protocol and adding that to the list of things that we discussed with everyone, because it will be useful to have that sorted out at the beginning rather than at the end.
Yes, agreed. Thank you.
So those are my suggestions on those issues.
Thank you, Ms. Mason. Mr. Lyle?
Yes, kia ora, sir. My client's been listening on the YouTube stream and is very comfortable with the submissions made by my friends, particularly those by the sites. The only point that I'd like to add is on funding, where claimants are and interested parties are unable to attend hearings because there's no funding available for that. We'd stress the importance of the live stream going ahead. And I can appreciate that in some instances that won't be probably practical or available given the sensitivity of some evidence, but where it can be, we'd really support that proceeding.
Thank you, Mr. Lau.
If you have any questions of me, those would be my submissions.
Thank you. Ms. Smale?
Thank you, sir. In terms of the contextual hearings, when I filed the memorandum, it was based on the minute directions that had previously come out. So I'd just like to speak to that briefly, because we did envisage that we did think that actually looked like quite a good idea. But having also then taken on board your comments from this morning, I've got some initial thoughts about that as well, which we would follow up with written submissions. We had so looking first at how we had understood you had been envisaging, the panel had been envisaging the contextual hearings. We had the sense that while the necessary preparation happens for a substantive hearing, and there's many steps, including statement of facts, disclosure, filing of evidence, Crown evidence, evidence reply, submissions, and that would naturally take many weeks over a few months. We could understand the value of, in the meantime, the tribunal being able to have a short hearing, getting a feel for the area, and that's how we sort of had envisaged the suggestion, and we were supportive of that. The way we had pictured it happening was as the panel had previously suggested, that was something quite informal, that it wouldn't necessarily need any preparation as such, and it would be a bit of a chance for the panel to become a bit more, gain a bit more knowledge about the area in preparation for receiving evidence. And the appeal of that was that it could happen in parallel to the work towards a substantive hearing. And we thought that it seemed more appropriate that that might be something where you might hear from perhaps not the whānau who've been impacted personally, but rather we had made a suggestion in the report of hearing brief reports from some of the authors of recent reports on Oranga, Tamariki, and maybe having a question and answer session. So being something quite different from a hearing where you would be necessarily putting up your substantive witnesses to present their evidence and then have to come back again. So we could definitely see the appeal in that, and I think that it could work in that way, help prepare the tribunal for the evidence to come. Having taken on board, though, the comments of other people about concerns about a doubling up and about the processes around that, and your comments at the beginning of this judicial conference, we also think that there's merits in the idea of looking at the systemic issues, perhaps it's not going to be called a contextual hearing anymore, but in a first hearing, we'd have to and having a subsequent part of the hearing, which is the whānau evidence, we'd have to think about and we'll provide some written submissions about how you might start those hearings earlier. It seemed like the context hearing, as you envisaged it, would happen very quickly. And I wonder how quickly a hearing, sort of an initial hearing about the substantive issues might be able to go ahead, because it seems like, for example, discovery and agreeing facts and a proper exchange of evidence is likely to be useful for that. So it may be that it's some months later than the date envisaged for July. But I do see a lot of merit in separating out the systemic an understanding of the system, and then having a completely separate hearing which might have completely different hearing rules or hearing sensitive evidence from people who have been affected by that system. And I think there's definitely merit in thinking about then perhaps having a systemic understanding of the system, much like a hearing that we're used to, but then making up completely different rules that are appropriate to the people who are going to present their own personal traumatic evidence, as is appropriate. And from my mind, those people perhaps don't need to prove their individual stories in the same way that witnesses about the system have to. And it could be that they're not asked questions at all, and that you have a closed hearing, and it's an opportunity for the tribunal to really understand the reality of the systemic problems. Now, the way, I guess, that if we were looking at my client's claim, is that they are, my client is on behalf of the National Urban Māori Authority. They are Māori organisations that are trying to support whānau in a different way than the Crown does. So in this claim, we're saying the Crown takes away a baby, and our clients say, well, if you did it, if Māori organisations, if a Māori community was running things, we would never take away that baby. We would support that whānau in whatever way we can. This is how we do that. That's talking about how we work within the system, how the system prevents us from doing that, and times when we've had success. And then we would be looking to, as I said in our memo, keeping our whānau evidence probably to just a couple of case studies, perhaps one of success where a whānau was able to be supported by a Māori organisation, and one of loss. And I can see that it tells a story together, but one side has a very different type of evidence. So those are some just initial thoughts from what you raised earlier, and we'll follow up with written submissions.
Kia ora, Ms. Smale. The points, you've made a number of good points, and you've correctly summarised how we originally saw what we described as contextual hearings. We haven't completely let go of the idea that something along those lines might be of value. However, when we met as a panel last week, and in light of the delays that have arisen from the whole COVID situation, and taking into account all the submissions we'd received and the further evidence from the Crown, we put forward a proposal, and in particular we put forward a possible way to summarise or break down the key issue that's being put before us into 3 questions at paragraph 12 of our last directions. Is Ms. Smale still? You've just gone off screen, Ms. Smale.
I'm still here.
All right, kia ora. So, for what we're now proposing to work, you're right to note that much depends upon how rapidly progress can be made with an agreed statement of facts and issues around the necessary base information to be provided, how quickly those matters can be resolved. So we'll consider what we hear from parties at the end of next week and give some further thought to what that means in terms of a realistic timetable. And also, if we're not able to use those late July dates in the way that we're currently proposing, what alternative use could they be put to that would help advance our preparation and the inquiry overall? So we'll take all of that into account. So thank you for your submissions.
Yeah.
All right. Ms. Castle?
Thank you, sir. Just a couple of brief notes. Our clients have shared concerns with those set out in the joint memoranda that have been filed around the contextual hearings. So I'm pleased to learn that the tribunal is now looking to hold them in a more conventional manner. In terms of the issue raised by Ms. Mason around wellbeing support, our client, Ms. Pickering, presented a statement to the Royal Commission and the contextual hearing in relation to her lived experience as in state care and also her practical experience as a social worker, and we had a discussion with her around the wellbeing support that was provided in that forum. She viewed it to be really important, but also for those who are going to be participating in the process to have some input into what an appropriate process might look like. And I note that Ms. Mason has sought that the Crown provide some information around what it might be able to make available.
Yes, thank you. We'll seek a response from the Crown on that in submissions at the end of next week. Thank you.
Thank you, sir.
Ms. Downs?
Tēnā anō koutou. Sir, I have 3 broad submission themes. The first one is in relation to the slight variance in the process, the proposed approach to the contextual hearings. And in our earlier memoranda, number 3.1.074, we had indicated that we wouldn't seek to participate and that we would maintain a watching brief. With the evolution of the scope of those hearings and a focus on systemic issues, we would seek to review that position. Our groups are representative and do have relationships with Oranga Tamariki, as well as a lot of experience with them. So they would look to bring evidence on systemic issues in those hearings as they arise. In terms of the protocol and confidentiality, we haven't been privy to the development of that. I think it falls on our undetermined status in the inquiry and the need to have our participation clarified. We had made submissions earlier that would be really helpful for our ongoing work with other counsel, as well as with the Crown. So I'll just indicate that I may not be available for that final discussion point later this evening. I do have to head off at 4:20 and seek your leave to do so. So any matters that arise in that discussion, we will submit following the Judicial Conference next week.
All right.
But on the protocol and what may have been developed, it seems that if the hearings are going to proceed with two broad processes, one in terms of the systemic issues and other in terms of case studies, that potentially a protocol could be developed that covers at a high level some of the confidentiality and process issues. And then as we get closer towards the hearings on case studies and as sensitivities emerge through the production of evidence and the briefing of evidence, if there are matters which aren't covered by that broad protocol, then we can seek to address those with the Tribunal and with the Crown. Which will mean that at the outset and earlier, some high-level agreements are reached in terms of how we deal with sensitive information. But as we proceed through the inquiry, if there are matters which are not covered by that protocol, we can deal with them as they arise.
All right, thank you.
The final submission is in relation to funding, and I think from the discussion that I'm hearing, there's slightly different claimant funding issues that are being discussed, and maybe a bit of clarification would be helpful in relation to the actual nature of the funding issues. And it falls on an issue that we've been raising for a number of years now, which is that there is no claimant funding for urgency and kaupapa inquiries, which means that when claimants need to attend hearings and have travel paid for and accommodation paid for and a recognition of the extensive contribution that they make through the what would have traditionally been a payment from CFRT for the preparation of a brief, those fees are not covered, or there's no funding available for those at all. And it places claimants in a very difficult position, as well as their lawyers, in terms of how do we get our claimants to hearing, particularly now that hearings are more centralised in Wellington or in urban centres. And we have raised this a number of times in both urgent and kaupapa inquiries, and I understand that there was an appointment of a committee of lawyers to deal with the Crown. There was an agreed work programme, and there hasn't yet been an update, and I think a lot of that is to do with COVID in terms of how far those discussions have gotten and whether a system has been developed for the provision of claimant funding for kaupapa and urgency inquiries generally. And it may be that because of the delays that have been caused by COVID, there isn't the ability for the purposes of this inquiry to have a funding regime applied that may apply generally to inquiries, but in my view, it's absolutely necessary for the claimant funding issue within the context of this inquiry to be addressed. And so considering how that may happen, it may be that a discussion is needed with the Crown over a special allocation to pay for or provide a regime, potentially modelled on a pre-existing CFRT claimant funding regimes, but to provide a regime for claimant funding to ensure that our claimants can get to the hearings and that we are not relying on AVL as a method for hearing simply because there is no claimant funding available.
Thank you. I take the point that we need to resolve as a matter of priority the question of participation of parties, including your clients, and we will look to do that in the short term so that all parties are able to work together on, wherever possible, agreed protocols, agreed statements of fact. So I note that. On the funding matter, as a first step, we'll seek some response from Crown Council and submissions at the end of next week, and consider where that leaves us. But thank you for raising that and clarifying the nature of the problem. Kia ora.
Those are my submissions, sir.
Thank you. And also you have leave to withdraw as need be. Kia ora.
Thank you.
Ms. Hall and Mr. Rogers.
So the New Zealand Maori Council's view is that any policy decisions made by this tribunal will result in policy which affects all Maori, and its concern and its question to the panel is how is it going to engage with Maori organisations with interest in tamariki care that are not involved in this Zoom inquiry, and how can other Māori participate, including participate in the design of the inquiry itself. If I can put it this way, sir, there's over 108 members on Māori committees brought together under the auspices of the Māori Community Development Act. 16 district Māori councils, 48 members of the New Zealand Māori Council, 144 Māori committees, and 1,008 individuals. Now, we use the Council's network to put out your most important 3 questions set out at paragraph 12 on the 7 May direction. That has gone right through the Māori Council network, and the members are here today waiting and are grateful that you have said they may have time to speak. And they've all been told that they'll be lucky to get 5 minutes and do not abuse that privilege. But they've been watching all day, and others, for example, have had as long as 55 minutes, and the chiefs of the paipai around the country are still waiting. So I'll put squarely on the table what I know they're going to ask for. What they are seeking is to know, will there be an opportunity to hear from Māori ourselves, Māori themselves, out in the regions, and that voice be heard first. Now, there's a lot of planning that's gone in already to the lawyer-led approach of a contextual hearing, and we understand that. But we wonder, sir, if it is possible to hear first from Māori themselves through the use of Zoom hui, and with a bit of goodwill. We note that over 1,100 voices were heard in the Māori inquiry. That grouping was heard within 2 months. 1,100 voices.
Sorry, on which inquiry, Ms. Hall?
Is there an ability?
Sorry, Ms. Hall. Which inquiry were you just referring to?
I was referring to the Oranga Tamariki report, the Maori inquiry into the Oranga Tamariki report.
It's the Whānau Ora Commissioning Agency?
They heard from 1,100 Maori voices within 2 months.
Ms. Hall, can I just clarify, that's the Whānau Ora Commissioning Agency report, is it?
Yes,
right.
Yes.
We were proposing, just, you probably have seen in our directions, we were proposing to call the commissioning agency to appear before us to speak to that report. And I understand what you're now raising is the possibility of a procedure whereby we would hear from representatives around the motu through techniques such as a Zoom. When did you envisage that process would occur? Is that as a first step?
We would ask that it goes ahead of the contextual hearings that are being discussed by my friends, that it should be the first voice that the panel hears. That is what we're asking for, and then to proceed with the contextual hearings that the work has gone into to date. And we do also ask that you bring on at an early stage in the inquiry the social workers, so that they may be heard and their evidence and their knowledge is able to be shared with the with Maori of the country and so that there can be an informed base as the rest of the inquiry proceeds. That is what I think you will hear. That is what I think they will ask for. In terms of the report from the whānau Auto Group, we're very comfortable just to take one page, page 70 of that report, which gives certain action points. It's a one-pager, but it does build on the call from whānau for by Māori, for Māori, with Māori solutions for long-term sustainability. This is a call that the people that are coming to the council share. And it's been very well articulated in just one page of that report. And so, sir, all what we would say is, if there can be a place made to hear from the Māori voice at the beginning, then to hear from the social workers, all focused to answering the systemic questions which you sent out, because that is what the Māori Council members have focused on. That's what they've been told is what they are to speak to. Today will confuse them a little, because now they're hearing there's lots of room for what they all want to talk about too, their own circumstances. And the council said, no, it's a systemic inquiry. You address these three questions and you stay in the parameters. So there does need to be some clarity. And if I can leave it there, sir, they are here waiting patiently and very grateful to be allowed the chance to speak.
Kia ora, Ms. Hall, thank you. And I acknowledge and thank your representatives for their patience. In terms of the last point you just made, the idea of case studies or particular circumstantial evidence is to illustrate or to give substance to those systemic issues which we have identified as at the core of the issue we've been given to inquire into. So what I'd ask after today's conference, in terms of the additional proposals you're making, is if by the end of next week you could file some further submissions outlining the nature of that process and how that might work and what kind of time would be required that would be of assistance. In terms of the procedure for today, I need to complete hearing from Claimant Council and Crown Council in response on this issue of what we're calling the context hearings. And to the extent that we still have some time remaining, I'll endeavour to come back to you and ask you in what particular order you had in mind we might hear briefly from those who are in attendance. So we're just close to a point where we're going to break. I'm going to go now to Ms. Napo Lipskin, the last of the Claimant Council, and then we may take the break and come back to Crown Council. So kia ora.
Kia ora, Your Honour. Thank you for the opportunity just to address those questions. So, Your Honour, I heard very clearly your comments that the participation of claimants issue will be resolved relatively soon. So I don't want to labour as to the participation of the claimants that I'm representing, but I do wish, however, just to highlight a few matters. The first one is that the Te Whāriki Mana Wahine o Hauraki, the Hauraki Māori Women's Refuge Centre, have asked that two witnesses be heard. One is Ms Denise Mesita, who is the manager of the Hauraki Māori Women's Refuge, and the second is Miss Josie Anderson. Both of those two deponents are experts in their field, and of particular note, Miss Josie Anderson was the CEO of the Hauraki Māori Trust Board, who was one of the only recognised trust boards in Aotearoa, New Zealand, to be given recognition under the Child, Youth and Family Act to be a state carer. So her evidence, I believe, would assist the tribunal immensely, both pre-1989 and post the changes in 1 July, which I understood the tribunal wanted specific evidence on. Secondly, Sir, in regards to Nicola Daly-Paki, she has her own evidence to give, but in particular, when her family court matters were still proceeding, there was a coroner's inquest. And the reason I raise this is because obviously the coroner's ability to call evidence, even when there is an active family court proceeding, had its own particular guidelines and protections put in place. During the coroner's inquest, a lot of the witnesses and the state witnesses that this tribunal has called were also called, and there were recommendations made by Coroner Bain that came post pre-1 July, and whether or not those have actually been implemented post 1 July, Sir. So that's just regarding the particular two of the claimants that I represent. I support the fact that if that leave should be sought in order to cross-examine any witnesses. And I also accept that the issue regarding special claimant funding for claimants to attend contextual hearing and further hearings is something that Claimant Council should be able to meet and discuss with the Crown. Also, I also support just further discussions with Ms Cassidy as well as Council to assist, Sir. Is there anything else in relation to the matters that I've raised in my memoranda dated 20th of March that the Tribunal wish to have expanded, or anything that you'd like me to address specifically?
No, not at this stage, thank you. Thank you for your submissions.
Thank you, sir.
Ms Hardy, we may take a short break and come back to hear from Crown Counsel. So what time are we due to finish, Robbie?
Break was due from 3:30 to 4, so come back at 4 and 20 minutes.
What time is the actual call finishing? 5? 5 o'clock. Right. We'll resume at 4 o'clock. Thank you, everybody. Kia ora koutou. Sorry, kia ora koutou. Ms. Hardy. Ms. Hardy, are you with us? Oh, there you are.
I am, sir, I was just struggling with my mute, but I think that's all working now.
All right.
Well, thank you, sir. Just to recap from what we've talked about so far, the Crown's process will be putting together a chronology, key facts to assist the process, and also be taking instruction to give the Tribunal and Claimant Council words on the disparity from 1989 on. And then obviously the Tribunal is going to take stock of what is filed next week to formulate the contextual hearings. But the more that I hear from Claimant Council, the more various are the options, understandably, for what is now 2 days of hearing, only 2 months after the receipt of submissions next week. And the Crown's request really of the Tribunal is to formulate some clear direction for everyone after next week. That is the challenging task of sorting amongst options. It could be that a contextual hearing is to hear further from the Crown about fundamentals of policy and legislation. It could be more along the lines of, I think, Ms. Hall's proposal, which is to capture Māori voices at a systemic level, or it could be some focus on a case study such as the Hastings case study. They probably can't all fit into the 2 days, so it's a question of what, in some ways, best assists the Tribunal working through an urgent hearing to come to some conclusions. So the Crown is open to those sorts of options, but some clarity with the issues to be addressed in the contextual hearing would be of great assistance. I do want to reiterate the Crown's concern about the Hastings case from different angles, the potential overlap with the family court proceedings, very conscious of the safety of the claimant witnesses, but also very conscious of the safety of the Oranga Tamariki staff who are involved, and that's uppermost in our minds too. And that stretches, in fact, to the filing of the video that was referred to as well. So we will want to make submissions on those aspects, and as Your Honour has asked, liaise with Council assisting. So I'm really just suggesting to the Tribunal that probably the shape and the content of the 2 days of contextual hearing can't be securely determined without a sense of the next steps on to conclusion of the urgency inquiry, and perhaps having a sense of that would give all participants more direction as to what goes in the contextual hearing, what it's contextual for, and where we're headed next. And appreciate that that will need to rest on points that are followed up by Council next week.
Thank you. On the question of some of the steps on which response from Crown is required, are you able to give any indication of what's a possible time frame within which, for example, an outline of the non-contentious facts and policy framework from 1989 could be framed up? I know there's already a reasonable amount of information on the record about that.
I could probably, Your Honour, get back firmly on that on Monday, but my expectation is that it wouldn't take, at least as an outline, too much more than a week or so. We've gathered together a fair amount of material, and I've heard from Claimant Council that they've pulled together some material as well. So I can certainly confirm that when I've taken instruction Monday, but I'm suggesting that kind of a time frame rather than a particularly much longer one.
That's helpful. I agree that there's a need for the tribunal to give clarity and guidance once we hear further from parties at the end of next week, and that's what we would be looking to do as soon as we can. In terms of how we approach the currently available days late July and any further hearing days, because we're open to the reality that we may need more than 2 days to hear what we're describing as contextual evidence. Those, or clarity around those matters in part depends upon how quickly the Crown and Claimant Council can advance agreement on that contextual framework and also resolve any matters that might remain about confidentiality or disclosure processes and protocols. So assuming we can get some further clarity around the likely timeframes for those matters to be advanced, and whatever remains unresolved and needing tribunal direction, the tribunal in turn can then settle on a clearer timeline and process towards first our July dates, and then beyond that, what a timetable might look like. Other matters have been raised too, Ms. Hardy, and if you wouldn't mind please taking instructions on matters such as the availability of counselling or support for witnesses, the matter that Ms. Mason and others have raised, and the more general issue of claimant funding, which has also been raised. The tribunal is not aware of the status of any ongoing discussions between a working group around that wider question, but to the extent you're able, if you're able to give an indication, that would be helpful as it relates to this inquiry. And with those, yep.
Oh, Your Honour, I was going to comment rather on the first point about counselling. The Crown did file a memorandum in the Mana Wahine claim that traversed that issue, but I think too it relates to the approach that the tribunal takes to the appearance of witnesses and the deployment of case studies as well. There was some suggestion, I think, from one council that the scene setting could be have an informality about it, or it could be something along the lines of the veterans' approach of having voices heard but without anything legalistic happening. That's another option, and certainly I can reassure that the Crown is not at all interested in amplifying the trauma of either the claimant witnesses or its own staff, so it's mindful of that. But that does go somewhat to the procedure that's adopted.
All right. There's a bit of a loop here, because what I'm endeavouring to indicate is that the procedure we choose in the short term is to a large extent going to depend upon the indication we get about how much can be broadly agreed in terms of context, which would enable the focus on the more recent changes and their actual or potential effect. So as I was indicating to Ms. Smale, our original idea for context hearings was more in the nature of an informal information gathering or proactive information gathering on the part of the tribunal, following which we would give more specific guidance to the parties for the rest of the inquiry. What we're hoping is that in light of our recent directions, we can advance more quickly to what we've described as a more substantive focus on the systemic issues based on those questions we've put at paragraph 12 of our last directions. So I don't know if that's a response to your submission, but at this stage we have an open mind about how best to proceed, but we would like to hear further at the end of next week about a range of matters that have come up today and in the written submissions. With regard to your concerns about the Hastings case and how that is managed, how quickly do you envisage having discussions with the council involved, including council assisting, so that we can consider the position of the parties further about how we approach that and the various matters that have been raised?
Well, Your Honour, in accordance with your direction, we would speak next week. But again, and perhaps this is part of the discussion, some clarity about what the inquiry of the tribunal is of the case and how it fits with the inquiry is what's important. I'll leave it at that, but that it's really the question of what we need to agree on that is of assistance to what the tribunal is interested in hearing.
So in the directions prior to, or when we first proposed what we're calling context hearings, we outlined why we thought the Hastings case may assist us. Are you seeking further detail or clarity beyond what we have so far said?
Well, perhaps that's a matter that we can discuss with assisting counsel. Yes, I would welcome discussion with her as to the focus of the evidence for any contextual hearing, because clearly there's a long tail of that is appropriately not before the tribunal in relation to the cases.
Yes. All right. Could you please advance those discussions with the council involved and council assisting? And we will consider submissions made and any report from council assisting and give further guidance or response as appropriate. Thank you.
Thank you, sir.
And just to be clear, in the responses next week, you'll be able to respond to the various matters Claimant Council have raised, including funding.
We'll look into that, Your Honour. It's it appears it's a general point rather than one focused on this particular claim. But yes, we'll cover that off in our memorandum to the tribunal.
All right. And in terms of procedures and processes that the tribunal needs to be aware of to respect the safety of your or Crown staff, could you also please discuss with council assisting what steps or processes you'd seek?
Yes, sir. I'll take instruction from my client on that and engage with the tribunal through council assisting.
Thank you. All right. I have nothing further at this stage, Ms. Hardy.
Thank you, sir.
Thank you. Can I just briefly ask Claimant Counsel, is there anything arising, just starting with Mr. Stone and the Joint Memorandum Council?
Your Honour, I don't have anything more to add today. I've looked at the remaining one. I think we've broken the back of things today, sir.
Thank you. Kia ora. Ms. Sykes, Mr. Benyon.
Yeah, I have an outstanding issue about the 30th and 31st of July. I'm unclear in this COVID environment when we will have any idea of what kind of limitations or otherwise may enable viva voce hearings, and that hasn't been explored today, but I think it needs to be done soon. I think it should be something responded next week. I'm also very conscious that this mechanism is not kanohi ki te kanohi of the kind that tikanga would ascribe, and in your honest memorandum of 2.5.19 paragraph 7, I just think if we want to achieve what you articulate compassionately there, then we need to provide a process, and if it has to be some adapted process of the kinds that District Court and High Court proceedings are talking about, we'll need to grapple with that early. And I don't intend to go further than that today, but it is a concern to my claimants.
Thank you. We acknowledge that, and like all parties, we're very much in the hands of matters unknown as to when we'll be able to resume hearings in a conventional way. We are hoping that by July we might be much closer to that, but at this stage it's a matter of watching and seeing what's possible, and we'll try to adapt our procedure accordingly.
I just want to note that, for instance, jury trials are still adjourned to the 2nd of August, so it's outside the date. So I imagine that there'll be some coalition of that. So I just raised it.
All right, thank you.
For that.
Mr. Benyon or Dr. Gilling?
Nothing further from me, sir. Thank you.
Kia ora.
Nor me, sir.
Kia ora. Ms. Castle?
Nothing further, sir.
All right. My apologies, Ms. Thompson and Mr. Tupara. Are you on the line still?
Yes, sir, I still am. I'm not too sure if my colleague is, though. Maybe she can respond. She's leading this claim that we've filed on behalf of a client in respect to this inquiry, sir. Hopefully she'll be able to respond or comment. If she's not on in the next few seconds, sir, I'll comment if that's agreeable to you.
Thank you.
Yes, tēnā koe.
My apologies, Ms. Thompson. I overlooked you in my list in the earlier matters. I apologise for that.
Sir, if we might be able to make some written submissions for next week on the matters that have been raised today, following the discussions.
Yes.
Otherwise we don't really have anything.
All right, thank you.
Say.
Ms.
And sir, if I may, if the record could be noted, our colleague, Mr. Charles Hirschfeld, had to rush away. His dad's been quite unwell, so if his apology through me could be tendered or noted. And he, together with myself and Ms. Thompson, subject to registration of the claim that was filed, will be leading that particular claim in due course, sir.
All right, thank you, Mr. Tupara. That's noted.
Yes, sir.
Ms. Mason, is there anything further arising?
No, sir, nothing except to say thank you to the panel.
Right, kia ora. Mr. Lyle?
So one matter, I'm not aware that any applications for media coverage were lodged for today, but apparently some media outlets have access to the live stream, and there's some quite long quotes from the lawyers involved today on some news sites, so that might be something that needs
All right.
to in future fixtures.
Just before the start of the conference this morning, I was told there was a request from, I think, Radio New Zealand. It was the only one that I was aware of. And as it was it is a judicial conference and a live stream conference, that request was allowed. I'm not aware of any other media in attendance, and my apologies for not noting that at the start of the conference this morning. But thank you for drawing that to my attention.
Sure, so I have nothing further.
Ms. Smale?
Nothing further today. We'll need to have a bit of a think and see what submissions we can provide that might be of assistance next week.
Kia ora. Ms. Downs, if you're still there.
Ms. Downs has left, but nothing further from Tuka, Your Honour.
Kia ora. Ms. Hall?
I have at Te Teko two speakers, Miss Tana Boasa Dean, you have her CV, and Mr. Tane Cook, who will follow me. But just briefly, if I can mention to you, sir, Mr. Tane Cook's role is a significant one in the Pukenga because he is the conduit between the two teams within New Zealand Maori Council involved with Oranga Tamariki. I lead the legal team before you today, sir, but there is a second team that's led by Mr. Matt Tukaki, where he runs the political arm of New Zealand Māori Council, and the council has signed a MOU with Oranga Tamariki to work through some of these most complex issues directly. If I can just put on the record before Mr. Cook starts that the New Zealand Māori Council takes its obligations pursuant to Section 18 of the Māori Community Development Act to work with government agencies like Oranga Tamariki very seriously in these situations. And so you do have two teams, and that's why we'll be asking for Mr. Tukaki's name to be taken off the claim that's currently being filed, and why today he is replaced by his deputy chair, Miss Raywin Harrison. So we now go to Tane Cook, sir.
Just before you do, Ms. Hall, I meant to mention to parties when we resumed after the break that one of our panel members has another commitment shortly after 5, so we'll need to conclude today's conference no later than 5 to 5. So we'll be looking to conclude at that time. And just before I go to your representatives, can I just complete with the last of Claimant Council, Ms. Napo Lipscomb, in case she had any final matter arising from discussions with Crown Counsel?
Kia ora, sir, thank you. No, I've nothing further to add. Thank you.
Kia ora, thank you. Ms. Hall.
Kia ora, Sir Lyle here. Before you go back to Ms. Hall, I need to seek leave to withdraw.
All right, granted. Kia ora, Mr. Lyle.
Yeah.
Kia ora, sir. It's Miss Rowton here from Tamariki Legal.
Yes.
Just if I can make a couple of comments, sir. We were...
Sorry, I missed you.
We had supported the joint memorandum, so I was just waiting until we got to agenda item 3 to make some comments, so if I may.
All right.
So just quite quickly, sir, on the disclosure protocol, it was noted in the joint memorandum filed yesterday that we would file some submissions on a protocol. So just to note that we would be working on that and would seek to provide that. I think that would need to be developed once scope has been decided. So just a note to you, sir. And secondly, just in response to the discussion this afternoon on claimant funding, just to support what my friend Ms Downs made submissions on, that issue of claimant funding is still unresolved. I think Ms Cole, Counsel for the Crown and the Housing Inquiry, provided an update recently, sir, on the status of, I think, these discussions between the Tribunal, the Crown and LAS, Legal Aid Services, to provide some kind of resolution to this issue. But I believe that because of COVID-19 delays, there hasn't been any communication about the result of that. And the funding that I believe Ms Hardy was referring to in the Manawahine Kaupapa inquiry, I believe that's specifically in relation to amount allocated for that inquiry. So that doesn't particularly answer the issue that we still have remaining in this inquiry. So those were just the comments that I wanted to make, sir.
All right, thank you, Ms Roughton.
Thank you.
Ms Hall.
Just to clarify, Your Honour, Ms Hardy here, that reference to Manawahine was about counselling, not funding. Just to clarify.
Thank you. Thank you, Ms Hardy. Ms Hall.
Yes, Tane Cook, sir.
Thank you.
Ahoia no tēnā koe e te kai whakamātau, e te kai whakawā kātira koutou. E whakarono mai nā e te tiro matahira ake nei kia tātou e tau nei. Tai hoa ko ahua. E te ahua hoi hoi hai. Ai te pēhea i aia nei. Nei. Kātira e te kai whakawā, tuatahi me huri au kia koe te pāpā tāmati, nāu i tuwhera, i wāhi tēnei wāhana ki tō tātou atua, ke whai mi tātou kina tikana, i waihua mai o tātou pākeke hui a korona, haiarahi, haiarataki i a tātou kātira kia koutou e nā kanohi pūreo, e tiro hia maina nā a ki te ahua o tēnei kaupapa kai mai o tātou aroa. E te kai whakawā ka roho tonu atua hau ki roto ki te reo matua ki tāi e au te whakatapoto te kotahina o nā whakaaro i whakaraupapa hia ki nei koe kātira koutou, anei tāku. Ko te ahua tana o nā whānau o roto o te tau 2022 te kau, kai te tino rereke ki te tapoto o te whānau o te tau kotahimano e iwarau e waru te kau mai. Ko tata tori te kaumātahi tau, mai tau wawāraraka ki tēnei wā, anō nei ko te reo, e tākere nei te kaupapa ko te reo, a te whānau, ko te reo, a te tamaiti, a ngā tamariki rānei, ko ia tāku e hia ki te whakatapoto ki mua i a koutou. Kia mārama hia koutou ko te reo, a wā tātou tamariki kārea no ko tino ronohia, i roto i te ahua e whakatapoto nei tātou i roto i tēnei wāna na whakā. Kai te rono tātou i te auwe, i te mamai, i te pōuri, i te nanawe, i te hahani, e noho mai na nā ki runa i o tātou whānau. Ka tika, mārama katoa tātou ki tēnā momo. Kāre he take mo tātou te noho ko nei, te whakarono haere i ērā kōrero i te mea mārama katoa tātou. Nari, ko te wāhana pēr kai te ahua wana nei mātou o roto mai o mātātua, kai te kōrero au mō nā whānau e noho mai nā i roto i te rohe o mātātua nei. E tāia eia te whakatakoto i te aroha, te manaki, te tiaki, te poipoi, te atawhai. Me wēnā tikana, i wēnā kaupapa i waihohia mai o tātou pākeke. Nō reira ko tāku kia koutou, kia koe te kai whakawa. Kia rono, kia āhei, kia whakai mai koutou ki te rono i tēnei reo, e whākina haere nau tēnei wā. Ka rau te kōrero mō ngā kōrero pōuri, hahani, na nawe anahe, enari kai te kōrero au mō nā reo o tua e te tiro whakamua ake. Kia tai ai, te whakaraupapa, te whakatakoto wātaka, a ka pēhea te oranga o te whānau, ka pēhea te oranga o te tamaiti, ka pēhea te oranga a ngā tamariki. kia marama tika ai tātou, ko ia te huarahi e whakatakoto nei tātou. Koina noi ho tāku e te hea e te kai whakawā e hea ki te whakatakoto ki mai ia koutou, ia tātou. Me tu whera te wāhana ki a tātou whānau rahi. Me huaki ai te wāhana, kia rono ai i ngā reo au tātou mātua, au tātou tīpuna, kia puta te pūwao te atatu, kia puta te pūwao tana o te ao, kia tae ai au, te kite i te rā momo i whakatakoto hia e te rani hau, i āia i whakatakoto i tāna tuhi, i ārā tau tuhi, i te tau, putahi mano e iwarau waru te kaumawaru te tau, te marama o hepete. Nā rātau tēnā kaupapa i whakatakoto, te kaumā toru katoa, ngā tikanga whakatakoto kōrero. Kui atu anō me huri ki tō tāmati riri, ko ia tētahi i whakaarohia, te reo o te whānau, te reo au tātou tamariki, kia rongohia, a kiri, a wairua, a ngākau, a katoa. Te tāia e tātou te rongo mā te waha noiho o te takoiti. Engari me whakatakoto hia kia whānui, kia whāroa, kia hohonu, kia ruruku, wairua hia, kia tāia te whakatakoto i ngāna nawe, engari kia puaea mai, ko te rongo wā, ko te wairua kakama, ko te wairua hihiko, kia tāia te utātu kirina ki wā tātou tamari. Nō reira, ko ina pia tāku kia koutou. Kua roa nei au e noho whakarono haere ki ngā kōrero, e kōrero hia nei me te rangatira o te whakā. Engari, tēnā koutou, kua rono au ia koutou. Engari, ka rekau au, kua rono mai ia hare, ia wiri, ia mārama, ia wai nei rānei, o huri no te motu, me te reo o tātou tamariki. So in parting, Your Honour, I'd just like to say that the voice of our people, the voice of family, the voice of children, the voice of old, the voice of past, now and the future, lays in the hands of the people that are on this call. Our children's voices are being heard loud and clear through the trauma and the fundamentals of their trauma. At the other end of that, of course, I judge is the vision past that, what that might look like and how that feels for us and me now, and what that feeling will harness moving forward. Because at the end of the day, as Māori, we feel more than we hear. What we hear sometimes gets a bit misconstrued about what we're influenced by. And this is a body that has great influence on the dimension of what family may look like in the future. We know what family looked like in our past. We now have an idea of what that looks like now, but creating what the voice sounds like moving forward, Your Honour, is something that I believe is fundamentally missing in some of the works that are being undertaken at this time. So with that being said, and thank you for allowing me these couple of minutes to place a whakaaro, a thought, and to elevate that thinking to a critical space where I know all of you on this court are at. Let the voice of the people be heard and felt, and let it be resonating amongst all New Zealanders across the country. Because what's good for families, Māori families, non-Māori families, is good for the nation. So that's all I have to add at this time. Thank you, Donna.
Tēnā koe, Mr. Cook. Tēnā koe mō tō whakaaro, whakaaro nui, whakaaro hohunu I horahia I a mātou. Nō reira, tēnā koe, ka huri ahau ki rautou te reo tuaroro o te motu. We will try to make the process that we have before us as inclusive as we can. And I hear the challenge that you lay before us, so thank you.
Thank you. So the next speaker is Taina Poasadine.
Kia ora.
Taina, are you there?
Kia ora mai rā tātou. Kei te pai te rono mai au, ne? Kia ora tātou. Tuatahi nā mihi whakaharahara ki nā mana, ki nā reo, kua hui mai. Kei te mihi ake anō ki tō tātou kakari ki te noho roa. Kua ahi pō i konei. Hoi anō. Tō tātou kaha ki te noho ki roto i tēnei wā tātou hui. Ki roto i tēnei kaupapa hohonu, pānui. He kaupapa matatini hoki. Tēnei, kei te mihi ake anō i o tātou pākeke, kei wana nui i a tātou. Ko te ringa tuku i te kupu tapu ki a ia i te wāhi ngaro, e noho mauri tau ai tātou, kia tātou anō. Ka rua, ko te koutou te rōpū whakamana i te tiriti o Waitangi. Tēnei te kupu nui atu ki a koutou. Ko nā kōkō raho, mō tēnei mea te whakawhata i te Tamariki, ko te whakanui i te arikitanga o te Tamariki. Ko nā kōkō raho katoa, ko nā kai kreme kai te kawe haere i tēnā o nā kōkora tēnei te mihi ake. Ahau, ko teina taku ingoa. He māngai kōrero ahau mo te runana matua o te kaunihera Māori. He tūhoi, he kahungunu, he raukawa, he Ngāti Toki ki Rarotonga, he Ngāti Toki ki Tahiti. O te taha o taku pāpā tēnā. Nō rua toki ahau, kai rua toki ahau i tēnei wātonu e noho ana. Ko taku mahi i te awatea, he kai pūtai au ke ahau tiro i te one one. Oira waku mahi i roto i te manatū o te tai ao. Tētahi waku ringa kai reira, ko tētahi waku ringa kai te manaki whenua i hamutana. Engari, kai wana nui kai roto i taku iwi e noho ana. Ka whakahaere hea waku mahi mai reira. Engari, i roto i tōku iwi, me tōku waka o mātātua, anei nā mahi e manoa nui katoa i ahau, e nā kau nui tiana e hau. He puta katoa mai nā inoinoi nā tono kia ahau. Kia huri haere ahau i taku rohe hei tapuhi. E hara te tapuhi i te midwife. Engari koe naka te mahi. He tapuhi ahau. I etahi wā, ka rereke te mahi a te tapuhi ki te mahi kari naki i te mārākai, ana koina tētahi o nā tohunatana o tōku whānau. He naki i te mārākai. Etahi o nā wāhana wera mahi e rua heri te tonu. Kāre he wehe e ai ki te kōrero a wōkukuia. Wōkukuia kuraua waku kai whakaako i ahau, ki te rā wāhana o nā mahi. Kai te pirani au te tiki atu i te matua o waku whakaaro. Ko te matua o waku whakaaro, ko te pāpā, ko te whāia, ko te māma, ko te tamariki, ko te pēpē. Ko tahi tonu. Tētai a te wehe i a rātau. I mua no atu i te whakaaro tana, kai te hia te wahine, he tamaiti, he pēpē, neha. Ko tahi tonu te whakaaro, ko tahi katoa mai tēnā whakaaro, ko tahi katoa mai te māma, te pāpā, me te wawata nui, te ingo nui, mo tā raua pēpē. Nō reira, ko etahi o nā wāhana wā mātau nā tapuhi i roto i tō mātau rohe. He haere mātau i te wā e tono ana, e putamena nā tono kia mātau, ki haere atu mātau, te noho i te taho, o te whānau, o te whāia, o te māmara nei, kua hapu. O etahi o nā tohu kia mātau, putamai we nā tohu mātau kuia, kuraua ko tēnei tonu, ko nā karakia, ko nā whakamoimiti, ko te māma, kua hapu, ko i ratana hapu tanga tuatahi, e karanga ana waku kuia, e ki ana, ko taua whāia, ko taua māma, mea ko i ratana pēpē tuatahi, e karanga hi ana ia, he aho te pairu ke aia. Ko te tikana, te hohonutana o tēnā kōrero, neha, o nā tana pēpē, kua uru mai, kua rauru mai, tana pēpē ki roto i te kōpū, ki roto i te mōwai ahuru, kua karangahia, kua aho te pairu ke te māma, o te nui whakaharahara, ko te rangatiratana o te pēpē tēnā. Oira tēnā tohu. Kua rana tira te pēpē nā te mea heke tika mai te pēpē i te wai ewe o nā rangi. Koira te kōrero mai a waku kuia kuraua ki ao. Ne, hara mai tēnā wai ewe ngā rangi i te hā o te atua. No nā whetū ke te mokopuna. Nā reira, e tai wā mātou whakarite haere i te āwhina i kia puta mai te pēpē ki te whai au ki te ao mārama. Ne, kua whakarite mātou nā wāhine, kua haere atu e tai wā mātou wāhine ki te waihana i etahi taonga nui mo te whakawhānau pēpē. E tai o nā taonga, ko te turuturu, he rākau. Ka purihia e te whāia nā turuturu i tāna whakawhānau mai tāna pēpē. Ko tētahi atu o nā taonga, ko te kōripi matā, he tā ngai, he tapahi i te pito o te pēpē. E rā taonga katoa hara mai te whenua, hara mai a papatuanuku, hara mai te rangi. He whakanui te rangatira tana o te pēpē.
Donna here, if I could ask, thank you, please. If we could move on, we've got the other districts, but thank you so much. Chair, can we now go to South Auckland to Papakura Marae? Chair, did you hear me?
Kia wai?
Tēnā koe, Ms. Boas. Dean, thank you for your kōrero.
Chair, if we could now move to Papakura Marae, we have there Miss Anne Kendall, who is the queer of the Marae, Mr. George Ngatai and Miss Raywin Bennett, and Papakura, if you wouldn't mind, could we hear from you, Raywin?
Kia ora, ko taratara taku maunga, ko whangaro taku moana, ko karangahapu taku marae, ko whānau pani taku hapu, ko ngāpui te iwi. Kia ora, my name's Raywin, and I guess what I wanted to just briefly talk about, because I see the time's moving on, and Your Honour, you said that you wanted to close off at 10 to 5. I briefly wanted just to talk about the systemic knowledge or the issues that I know that I've seen over the past 30 years working in South Auckland within the organisation of Oranga Tamariki. I also wanted to just talk about, if you want to look at evidence base, it's in every office that we have up here in terms of cases that people are working on. And I also wanted to just briefly touch on that in 1989, when it was mandatory that all public servants had to be trained for to deliver Pāo Te Atatu. That was mandatory for every one of us within Oranga Tamariki, well, back then, Department of Social Welfare, that actually the 10,000 mokopuna who were in care were reduced within that year down to 5,000 when there was a conscious effort made that you had to consult whānau hapuanui. So I guess at another stage when we were able to have more time to kōrero, I could talk on some of those issues that I've just raised. And I'm now going to just hand it over to George.
Tēnā koe, Ms. Kendall. Thank you. Can I just clarify in response to that for you and for the others who are speaking and who have been waiting for a long time. Today's conference is largely to help the tribunal plan how we set a scope and set up a structure for our inquiry. So the matters that you're touching on go to what we're calling the systemic issues we need to understand. So what we're seeking today and what we will be looking for next week with further submissions is the ideas that will help us focus on that key question that we've been given as to why there is this disproportionate number of Tamariki Māori. So what I'm saying is we're not in a position to hear the actual evidence today, but we are looking for further guidance and further ideas as to how we advance that taki. So thank you.
Ngā mihi. Kuku.
Kia ora, Your Honour. George Ngatai. Look, as a former manager and CEO of an iwi social service, I suppose one of the biggest challenges we had as an organisation was actually being allowed to care for our children and have them returned from the state to actually be in the care of iwi. And one of the biggest challenges I had back 20 years ago was the fact that there wasn't a lot of, I suppose, interest to have our tamariki of Ngāti Awa descent at that time to be given back to the care of the iwi because of the ideas that a lot of the social workers or state workers did not actually believe, from my perspective, that iwi were able to actually care for these children appropriately. And so Raewyn actually was a state worker at that time. And of course, I was actually working in the iwi as part of the iwi social services. And unless you actually had somebody that was willing to engage with iwi and to transfer that responsibility between both the state and the iwi to care and look after those tamariki, it wouldn't actually have happened. So when Raewyn spoke about the fact that in the year of 1989, where there were 10,000 tamariki in care, went down to 5,000 tamariki in care, that was predominantly to do with the fact that they had engaged Māori staff within the department, had actually engaged appropriately with iwi based out in the community, and that agreement was actually given. Today, that is actually more challenging, and so therefore I think that there needs to be a lot more of Māori or culturally appropriate people within the department that has that conversation with iwi to be able to move forward. So briefly, that's probably what I wanted to actually contribute today.
Thank you. Tēnā koe, Mr. Ngātai. Could I just ask that you talk to your council about what information or evidence you might be able to put together for this tribunal that speaks to what you have just told us in terms of what was happening, what happened after Poau Te Atatu, and what has happened since. So it would be helpful if you can talk to Ms. Hall about what information, what evidence could be brought forward about that. Thank you.
Thank you, sir. Could we now move to
Ms. Hall,
Waipapa Marae, to Hastings, to Derek, Derek King, and to Ngātai Huata, and to Ngāhiwi Tomoana.
All right.
Can we hear from one of you, please? We do have
Ms.
a
Hall,
few more.
this will probably have to be the last. I think we're going to need to close after this. If
Derek, you're our last presenter, but if we can pass it to Ken Kennedy, Dr. Kennedy, to close for us, that'd be great. Can we hear from you, Derek? Okay, here, Derek.
Can you hear me?
Kia ora.
Kia ora. Kia ora koutou. My name is Derek Huata King. I'm chairman of the Taki Tumu Council. Now, I have heard what people have said all day, and I heard this Hastings case being mentioned quite a few times. That's just one aspect of horrific abuse that has happened in the case of our tamariki. We're sick of going down grievance mode. We want to get out of grievance mode, and our whole aim is to set up our own infrastructure to look after our own children. When I'm here, Miss Hardy, she's a rep for the Crown, is that right? Well, I'm not keen on talking to our abuser. She's asking us to sit down and kaupapa. She should sort out her own department. They're the biggest abusers.
Mr. King, so I have to stop you there. Our process, we need to hear from the Crown. So we only have a brief time before I need to close.
Okay then. Judge, I'd just like to point out, you keep on bringing up the Hastings case. That's just one of the horrific cases that has happened in Kaununi. A lot of our tamariki here have been sexually abused, battered, murdered. When you talk about just the Hastings case, you're not talking fairly about all abuse that has happened. and it's been done by the Crown agency. They're the biggest abuser. And we want to take over our own Tamariki. You know, I'm tired of having a partnership with an abuser who's not prepared to change their ways. We are prepared to look after
Derek.
our own
Derek,
Tamariki.
Derek, if I
Yeah.
may, this is our very important Waipapa family from Hastings that you're hearing from. If I could now, in the very short time we have left, if I could apologise to the rest of the Māori Council members who I know have been waiting to be heard, but we're out of time. Can we all agree we go to Dr. Ken? Dr. Ken, are you online? Can you close for the council?
Tēnā koutou, e te kai whakawā, makaere, o tira ngā mema whakamana i te Treaty o Waitangi tēnā koutou. My name is Dr. Ken Kennedy. I am the chairperson of the Hinakura Māori Committee of Te Arawa Waka, and we sit under the umbrella of the New Zealand Māori Council. I want to acknowledge my niece, Janet Sykes, and of course our karaua Major Te Rewhati Wekau from Ngāti Hinakura. He was instrumental in providing the government with expertise, advice, looking through a Māori lens during his time with the overhaul of the Māori Community Development Act of 1962. And from that act, the New Zealand Māori Council was established, and here we are, the New Zealand Māori Council today. I understand I'm the last speaker for the Māori Council today, so I want to acknowledge the Judge, Michael Dugan, for allowing us this brief time. I support everything that the Māori Council speakers have said today. Oranga Tamariki need to live, breathe, and understand whakapapa. The current Oranga Tamariki structure is not in that space at the moment, and if they don't live, breathe, and understand whakapapa, they are not going to get it. They didn't get it back in 1988-89 with Puao Te Ata Tū. If they don't bring that on board, they won't get it today. E te ahorangi pau, us of the Māori Council believe that a model that sits in joint partnership with the karauna, the kāwalatanga, the tari o te kāwalatanga, me ki Oranga Tamariki, that would be a close relationship where Māori will join with the Crown, not being led by the Crown ka. We need to work together as a joint partnership for this structure to work. Nō reira, e homa, tēnā koutou, kia ora tātou katoa.
Tēnā koe. Tēnā koe, Mr. Kennedy. Thank you. Thank you, everybody who's been in attendance. Council, for your assistance. All the parties, all those watching. Tēnā koutou katoa. I'll just hand over now to Matua Pou to close. Kia ora.
Kāre he kōrero I kone ki tāmati. Kai te haere tunu atu kia koe I nāia nei. Kia poto tō karakia. Kāre he mihi muri atu I tēnei. Katia tātā tau hui.
E whae te atua ka harawa kia tau ai mana kitanga ki ngā ki tō mātou prei punare e kimi huarahi nei o mātou katoa. Kia tau ki a tātou katoa te ata whai o tō tātou ariki. Te arohau te atua e te whiwhingatahitanga ki te wairua taku ake. Amen.
Kia ora.
You finished? Can you turn it up?
Kia ora. Thank you. Panel, let's